Department of State sent staff and reached out to the committee to, quote, discuss accommodations. As you all know, the accommodation process is when Congress and the executive branch discuss priorities and concerns so that the committee gets what it needs most efficiently while minimizing any burden to the agency. So on October 7th, the committee staff met with State Department officials. During that conversation, the committee made a good faith attempt to engage the department in negotiations. To start, the committees requested that the department prioritize the production of a narrow set of non-privileged documents. The department representatives stated that they would take the request back to senior State Department officials. But that was the end. That was the end. Those priority documents were never provided to the committees. In addition to the State Department, the Department of Defense also showed an initial interest in cooperating. During an October 13 television appearance, Secretary of Defense Mark Esper stated repeatedly that the Department of Defense would seek to comply. He said on air, on TV, that they would seek to comply with the subpoenas. In an exchange on Face the Nation, he was specifically asked, question, very quickly, are you going to comply with the subpoena that the House provided you and provide documents to them regarding the halt to military aid to Ukraine? Answer from the Secretary, yeah, we will do everything we can to cooperate with the Congress. Just in the last week or two, my general counsel sent out a note, as we typically do in these situations, to ensure documents are retained. But again, the question is that a yes? Answer by the Secretary, that's a yes. Question, you will comply with a subpoena? Answer again by the Secretary, we will do everything we can comply. These are his very own words. We can comply. We can comply. But remember that October 8th letter from the White House counsel sent to the Speaker stating that the President's position of total defiance. President Trump, again, I'll quote it, had said, President Trump cannot permit his administration to participate in this partisan inquiry under these circumstances. So every department, every office, top to bottom of the executive branch was under these instructions. You know, that is about 2 million public servants, top to bottom. The executive branch, all ordered by President Trump not to provide information to Congress. The President offered no accommodation and no opportunity for negotiation. Ultimately, each agency and office followed the President's order. In response to each subpoena, the Trump administration produced no documents, nothing, nada. And the agencies and offices made clear that it was due to the President's instructions. They always deferred to that October 8 letter. For example, despite the Secretary's initial signal of cooperation, I gave you the quote when he was asked specifically on TV. He said they would try to cooperate. But despite that, the Department of Defense later refused to respond to the committee's subpoena. In a letter to the committees, the Department of Defense echoed many of the White House's unsupported legal arguments and concluded, and I quote, in light of these concerns and in view of the President's position as expressed in the White House counsel's October 8th letter, and without waiving any other objections to the subpoena that the Department may have, the Department is unable to comply with your request for documents at this time. Again, on a TV interview on Face the Nation, they tried to ask him again. So when asked by Chris Wallace on Fox News, question, but do you feel Congress has the right to oversight and to be able to see documents from the Pentagon about a program that was approved by Congress? Answer, well, they do, but provided it's done in the right way and proper way. And I think that was the issue. Again, I think my reputation is pretty good in terms of being very transparent. I like to communicate with members of Congress, but in this case, my recollection is that they were technical and legal issues that prohibited us from doing exactly what was requested by Congress. So he said he would try to cooperate, to seek to comply, but now they're backpedaling. But, Senators, there was no valid technical or legal arguments. None were put forth to justify the stonewalling of the impeachment inquiry. The documents President Trump is withholding are highly relevant, responsive, and would further our understanding of the President's scheme. Here is just a sampling of the documents we know exist that are currently being withheld. National Security Advisor John Bolton's notes, Ambassador Taylor's first-person cable to Secretary Pompeo, emails between OMB and other agencies about the President's directive to place a hold on the Ukraine military aid, and the hundreds of heavily redacted documents that the administration now turned over to third parties under FOIA court orders. Certainly the documents released pursuant to the FOIA lawsuits were not subject to any claims of privilege or confidentiality or burden. The administration released them publicly. By contrast, the President turned over nothing in response to the House impeachment investigation. Now, Senators, there still is another component of the President's obstruction that I want all of us to focus on. Not only did the President block agencies and offices from producing documents, his administration also blocked current and former officials from identifying, producing, or even reviewing relevant documents. First, the Trump administration actively discouraged its employees from even identifying documents responsive to the committee's requests. Deputy Assistant Secretary George Kent testified in his deposition that he informed the State Department attorney about additional responsive records that the department had not collected. According to Kent, the department attorney, quote, got very angry and, quote, objected to Kent raising of the additional information. He, quote, made clear that he did not think it was appropriate for Kent to make the suggestion. So here's a lawyer telling the witness, don't say that. I just, frankly, as again, a lawyer and former judge, I just can't believe something like this would happen. But Kent responded that he was just trying to, quote, make sure that the department was being fully responsive. Second, the Trump administration refused to permit individual witnesses to produce relevant documents themselves. After the State Department failed to respond to voluntary requests for documents at the beginning of the investigation, the committee sent document requests to 6 individual State Department employees. Secretary Pompeo objected to the committee's request to state officials, calling them, quote, it's an act of intimidation and on an invitation to violate federal court laws. He also claimed that the House inquiry, quote, an attempt to intimidate, bully, and treat improperly the distinguished professionals of the Department of State. Now, we were the bullies. But let's be clear. His statement has been contradicted by actual State Department professionals from whom the committee sought documents. Kent testified that he, quote, had not felt bullied, threatened, and intimidated by the House. In fact, Kent said that the language in Secretary Pompeo's letter, which had been drafted by a State Department attorney, was without consulting Mr. Kent. He said, quote, it was inaccurate. Inaccurate. Then the State Department ordered witnesses to withhold documents from Congress. For example, on October 14, the Department sent a letter to Kent's personal attorney warning, quote, your client is not authorized to disclose to Congress any records relating to official duties. Certain witnesses defied these orders and produced the substance of key documents, providing critical insight into the President's scheme. Other witnesses produced documents to the Trump administration so they could be turned over to Congress. But now the administration is also sitting on those documents and is refusing to turn them over. Ambassador Taylor testified that he turned over documents to the Trump administration, but to his knowledge, they had not been produced to the House. Let's watch.
But has any of the documents that you turned over, to your knowledge, been turned over to the committee?
No.
Well, Senators, I will confirm the committees have not seen not one of these documents. None. Finally, if it could be any worse, well, it is. A Trump administration official, Ambassador Sondland, informed us that he was not even permitted to review his own relevant records in preparation for the testimony. Again, this would be his own records so that he could prepare to testify. So let's watch.
I have not had access to all of my phone records, State Department emails, and many, many other State Department documents. And I was told I could not work with my EU staff to pull together the relevant files and information. Having access to the State Department materials would have been very helpful to me in trying to reconstruct with whom I spoke and met and when and what was said. My lawyers and I have made multiple requests to the State Department and the White House for these materials. Yet these materials were not provided to me, and they have also refused to share these materials with this committee. These documents are not classified, and in fairness, should have been made available.
Of course, we agree. At President Trump's order, agencies and offices refused to produce documents in response to the committee's requests, and they refused to allow individual witnesses to do so either. So let's recap. No documents, zero, goose egg, nada, in response to over 70 requests and 5 subpoenas. No attempt to negotiate. No genuine attempt to accommodate. Categorical, indiscriminate, and unprecedented stonewalling. Again, never in my time as a lawyer or as a judge have I seen this kind of total disrespect and defiance of a lawfully issued subpoena, and all on President Trump's orders. And it could continue, because this obstruction of Congress is real, and it's beyond comparison. This president should be removed.
Mr. Chief Justice and Senators, let's turn to President Trump's efforts to stop witnesses from testifying. No other president facing impeachment has taken the extreme step to prohibit executive branch witnesses from testifying before Congress. Even President Nixon, who famously attempted to defy a subpoena for tape recordings of his conversations, he let his most senior staff testify before Congress. Now, I remember listening on TV as John Dean testified before the Senate Watergate Committee. He was the president's lawyer. President Nixon didn't block him. Not only did President Nixon allow his staff to testify before Congress, he publicly directed them to testify, and without demanding a subpoena. Actually, with the Senate Watergate investigation, President Nixon said, and this is a quote, "All members of the White House staff will appear voluntarily when requested by the committee. They will testify under oath, and they will answer fully all proper questions." Now compare to President Trump. He publicly attacked the House's impeachment inquiry, calling it, quote, "constitutionally invalid." And he ordered every single person working in the executive branch to defy the House impeachment inquiry. As just discussed, in the letter to the Speaker of the House, the White House counsel said that President Trump, quote, "cannot permit his administration to participate." No president ever used the official power of his office to prevent witnesses from giving testimony to Congress in such a blanket and indiscriminate manner. There's no telling how many government officials would have come forward if the president hadn't issued this order. Let's look at some of the witnesses who followed the president's orders. The House issued subpoenas to compel the testimony of 3 officials at the Office of Management and Budget: Acting Director Russell Vought, Associate Director Michael Duffy, and Associate Director Michael McCormick. Now, according to the testimony in the House, which was reinforced by emails recently revealed through the Freedom of Information Act lawsuits, OMB was just central to the president's hold on security assistance to Ukraine. Its officials served as conduits for the White House to implement the hold without directly engaging the agencies that actually supported release of the aid. President Trump directed these 3 OMB officials to violate their legal obligation by defying lawful subpoenas, and they followed his orders. This isn't just an argument, it's a fact. In response to House subpoenas, the OMB sent a letter to Chairman Schiff refusing to comply, and this is what the letter said. As directed by the White House counsel's October 8, 2019 letter, OMB will not participate in this partisan and unfair impeachment inquiry. In that simple statement, OMB admitted several key points. First, Mr. Cipollini's letter of October 8th was an official directive from the White House. Second, President Trump's blanket order applied to OMB and the 3 officials subpoenaed by the House. Third, President Trump's blanket order not only directed them to refuse to participate voluntarily, it also directed them to defy House subpoenas. Fourth, President Trump's blanket order directly prevented the 3 OMB officials from providing testimony to the House. There's no question about the scope of President Trump's order. It was total. There's no question about the intent of the order. It was clearly understood by administration officials as shown by OMB. And there's no question the order had an impact. It directly prevented the House from getting testimony from the 3 senior officials at OMB. So here we are. The President of the United States issued an official order forbidding every single person who works for the executive branch of our government from giving testimony to the House as part of an impeachment investigation. That order prevented the House from getting testimony from witnesses who knew about the President's conduct. The matter is simple, it's plain to see. The question we here in Congress must ask is whether we're prepared to turn a blind eye to a President's obstruction. Obstruction not only of oversight, but also the power to determine whether Congress may gather evidence in an impeachment proceeding. If the Senate is prepared to accept that, it will mean that not only President Trump, all presidents after him will have veto power over Congress's ability to conduct oversight and the power of impeachment. The House was not prepared to accept that, and that's why the House approved Article 2. As you consider what you think about this, please know that President Trump's blanket order was not the end of his campaign to obstruct the impeachment inquiry. Actually, it was just the beginning. In addition to his total ban of government witnesses, President Trump also sent specific explicit orders. He directed key witnesses to defy subpoenas and to refuse to testify as part of the House's impeachment inquiry. As you know, the House subpoenaed acting White House Chief of Staff Mick Mulvaney. We wanted his testimony. At a White House press briefing in October, I know you've seen it before, Mr. Mulvaney confirmed what we had suspected. Mr. Mulvaney admitted that President Trump withheld the aid to pressure Ukraine into announcing an investigation into the conspiracy theory that Ukraine interfered in the 2016 elections. Here's his words.
Did he also mention to me in the past the corruption related to the DNC server? Absolutely. No question about that. But that's it. And that's why we held up the money.
After this really stunning admission, the House issued a subpoena to require Mr. Mulvaney to testify. But on the day of Mr. Mulvaney's scheduled deposition, the White House sent a letter to his personal attorney. It prohibited from obeying the subpoena. And the letter said, quote, "The President directs Mr. Mulvaney not to appear at the committee's scheduled deposition." When he issued this order, President Trump doubled down on his previous blanket order. He did so after the House voted to approve Resolution 660, which in no uncertain terms made clear that Mr. Mulvaney was being subpoenaed to testify in an impeachment investigation. This order was the first of many. President Trump also ordered another White House official, Robert Blair, not to testify. Mr. Blair is Mr. Mulvaney's senior advisor and his closest aide. He was involved in communications about the hold on Ukraine aid. The day after his initially scheduled deposition, Mr. Blair's personal attorney sent a letter to the House. It said, quote, "Mr. Blair has been directed by the White House not to appear and testify." The House also wanted testimony from John Eisenberg, the senior attorney on President Trump's National Security Council. As you've heard over the past few days, key witnesses, including Dr. Hill, Lieutenant Colonel Vindman, said they were concerned by President Trump's efforts to pressure Ukraine. They were told to report these concerns to Mr. Eisenberg. On the day before his scheduled deposition, the White House sent a letter to Mr. Eisenberg's personal attorney. It said, quote, "The President directs Mr. Eisenberg not to appear at the committee's deposition." Now, that language is starting to sound familiar. Mr. Eisenberg's personal attorney then sent a letter to the House. The letter said this: "Under these circumstances, Mr. Eisenberg has no other option that is consistent with his legal and ethical obligations except to follow the direction of his client and employer, the President of the United States. Accordingly, Mr. Eisenberg will not be appearing for a deposition at this time." Now, that language, I think, is important, and it's telling. It shows that President Trump's order left Mr. Eisenberg with, quote, "no other option that is consistent with his legal and ethical obligations." By directing him to defy a lawful subpoena, President Trump created a legal and ethical problem for Mr. Eisenberg. I'm sure you know, contempt of Congress can be punished as a criminal offense. It carries a possible sentence of up to 12 months in jail. No president has ever dared, during an impeachment inquiry, to officially and explicitly order government witnesses to defy House subpoenas. You don't have to consider high-minded constitutional principles to understand why this was wrong. It's simple, really. By ordering specific government officials to defy congressional subpoenas, President Trump forced those officials to choose between submitting to the demands of their boss or break the law. Nobody should abuse a position of power in that way. But President Trump specifically ordered all three of these senior White House officials, Mulvaney, Blair, Eisenberg, to defy the House's subpoenas and refuse to testify. President Trump's efforts to conceal his actions didn't stop there, and they didn't stop at the front door of the White House. No less than 12 other witnesses were specifically ordered not to testify. One of those witnesses, Ulrich Brechtbull, hasn't been highlighted much over the past few days, but the way he fits into the story is worth noting. Mr. Brechtbull is a senior official at the State Department. Like these other senior officials, he was ordered not to testify. In a letter to the House, his attorney said, quote, "Mr. Brechtbull has received a letter of instruction from the State Department directing that he not appear." Mr. Brechtbull is still another person who could shed light on President Trump's actions. He was kept updated on Rudy Giuliani's broader efforts in Ukraine. He had firsthand knowledge of Secretary Pompeo's involvement. For one thing, he handled Ambassador YOVANOVITCH's recall from Ukraine, though he refused to meet with her in the aftermath. Also, messages by Ambassador Volker show that Mr. Brechtbull knew about Mr. Giuliani's efforts in the Ukraine as they occurred. On July 10th, Ambassadors Taylor, Volker, and Sondland discussed Rudy Giuliani's push abroad. While discussing the problems Rudy was creating by meddling in official U.S. foreign policy, Ambassador Taylor noted that he, quote, "briefed Ulrich this afternoon." Also on August 11th, Ambassador Sondland emailed Mr. Brechtbull to ask him to brief Secretary Pompeo in a statement he was negotiating with President Zelensky, the aim of, quote, "making the boss happy enough to authorize an invitation." Ambassador Sondland wrote to him, quote, "Kurt and I negotiated a statement from Z to be delivered for our review in a day or two. The contents will hopefully make the boss happy enough to authorize an invitation." Now, State Department Executive Secretary Lisa Kenna answered Ambassador Sondland several hours later, letting him know that she'd passed that information on to Secretary Pompeo. Let's consider and pause here why this message to Mr. Brechtbull, which the State Department continues to conceal, is important. In this exchange, Ambassador Sondland told Brechtbull that he had negotiated a deal to get President Zelensky to make a statement, and that Sondland hoped that the promised statement would, quote, "make the boss happy enough to authorize an invitation." It shows that senior State Department leadership, including Secretary Pompeo, were quite aware of the deal to trade an invitation to the White House for a statement from President Zelensky. Indeed, Ambassador Sondland confirmed that he kept them in the loop. Here's his testimony.
We kept the leadership of the State Department and the NSC informed of our activities, and that included communications with Secretary of State Pompeo, his counselor, Ulrich Brechtbull, his executive secretary, Lisa Kenna, and also communications with Ambassador Bolton, Dr. Hill, Mr. Morrison, and their staff at the NSC. They knew what we were doing and why.
8 other witnesses were also ordered not to testify as part of the House's impeachment inquiry. But those 8 witnesses came forward anyway, despite the President's efforts to prevent them from testifying. All of the following witnesses were told not to testify: Ambassador Marie Yovanovitch, Ambassador Gordon Sondland, Deputy Assistant Secretary of State George Kent, Ambassador Bill Taylor, Deputy Assistant Secretary of Defense Laura Cooper, Deputy Associate Director at OMB Mark Sandy, State Department official Catherine Croft, and State Department official Christopher Anderson. Each of these 8 witnesses followed the law. They obeyed House subpoenas, and they testified before the House. In all, we know that by issuing the blanket order and later specific orders, President Trump prevented at least 12 current or former administration officials from testifying during the House's impeachment inquiry. He specifically forced 9 of those witnesses to defy duly authorized subpoenas. The facts are straightforward and they're not in dispute. First, in the history of our republic, no president ever dared to issue an order to prevent even a single government witness from testifying in an impeachment inquiry. Second, President Trump abused the power of his office by using his official power in an attempt to prevent every single person who works in the executive branch from testifying before the House. Finally, President Trump's orders, in fact, prevented the House from obtaining key witness testimony from at least 12 current or former government officials. President Trump's orders were clear. They were categorical, they were indiscriminate, and they were wrong. They prevented key government witnesses from testifying. There's no doubt. That's obstruction, plain and simple.
Now let us turn to some final set of facts. In a further effort to silence his administration, President Trump engaged in a brazen effort to publicly attack and intimidate the dedicated public servants who came forward to testify. To be clear, these witnesses didn't seek the spotlight in this way. For years, they had quietly and effectively performed their duties on behalf of our national interest and on behalf of the American people. Why would they seek the spotlight in this way, knowing that the President of the United States would lead the chorus of attacks against them? And he did. In response, the President issued threats, openly discussed possible retaliation, attacked their character and patriotism, and subjected them to mockery and other insults. The President's attacks were broadcast to millions of Americans, including the witnesses, their families, their friends, and their co-workers. This campaign of intimidation risks discouraging witnesses from coming forward voluntarily or complying with mandatory subpoenas for documents and testimonies. And as we all know, witness intimidation is a federal crime. There is simply not enough time today to walk through each of the President's attacks on the House's witnesses. But let's talk about a few. As I am sure my colleagues recall, the House subpoenaed Ambassador Marie Yovanovitch for public testimony. Ambassador Yovanovitch's first tour was in Somalia, an increasingly dangerous place as that country's civil war progressed. During a different tour, when Ambassador Yovanovitch helped to open a U.S. embassy, during which time the embassy was attacked by a gunman who sprayed the embassy building with gunfire. Ambassador Yovanovitch has also served as ambassador to Armenia and served the U.S. Embassy in Moscow. As Chairman Schiff said earlier, she has served in some dangerous places around the world on behalf of our interests and the interests of the American people. President Trump's Undersecretary of State for Political Affairs described Ambassador Yovanovitch as, and I quote, an exceptional officer doing exceptional work at a critical embassy in Kyiv. But during Ambassador Yovanovitch's public testimony, President Trump tweeted, "Everywhere Marie Yovanovitch went turned bad." She started off in Somalia. How did that go? Then fast forward to Ukraine, where the new Ukrainian president spoke unfavorably about her in my second phone call with him. It is the U.S. president's outright or absolute right to appoint ambassadors. In that same hearing, Chairman Schiff asked Ambassador Yovanovitch for her reactions to the president's attacks during her testimony before the House. Let's listen to that exchange.
Ambassador, you've shown the courage to come forward today and testify. Notwithstanding the fact you were urged by the White House or State Department not to, notwithstanding the fact that, as you testified earlier, the President implicitly threatened you in that call record, and now the President in real time is attacking you. What effect do you think that has on other witnesses' willingness to come forward and expose wrongdoing?
Well, it's very intimidating.
It's designed to intimidate, is it not?
I mean, I can't speak to what the President is trying to do, but I think the effect is to be intimidating.
Well, I want to let you know, Ambassador, that some of us here take witness intimidation very, very seriously.
The House also subpoenaed the public testimony of Ambassador William B. Taylor, another career public servant who graduated at the top of his class from West Point, served as an infantry commander in Vietnam, and earned a Bronze Star and an Air Medal with the V device for valor. Yes, yet shortly after Ambassador Taylor came forward to Congress, President Trump publicly referred to him as a never-Trumper without any basis. And then, when a reporter noted that Secretary of State Mike Pompeo had hired Ambassador Taylor, President Trump responded, and I quote, "Hey, everybody makes mistakes." He then had the following exchange about Ambassador Taylor. Let's listen.
Do you want him out now?
He's a never-Trumper. His lawyer's the head of the never-Trumpers. They're a dying breed, but they're still there.
Ambassador Taylor has since stepped down from his position as our chief diplomat in Ukraine. In addition to his relentless attack on witnesses who testified in connection to the House's impeachment inquiry, the President also repeatedly threatened and attacked the member of the intelligence community who filed the anonymous whistleblower complaint. In more than 100 statements about the whistleblower over a period of just 2 months, the President publicly questioned the whistleblower's motives and disputed the accuracy of the whistleblower's account. But most disturbing, President Trump issued a threat against the whistleblower and those who provided information to the whistleblower. Let's listen.
I want to know who's the person that gave the whistleblower, who's the person that gave the whistleblower the information? Because that's close to a spy. You know what we used to do in the old days when we were smart, right? With spies and treasons, right? We used to handle it a little differently than we do now.
The President's need to conceal his actions was so extreme that he even attacked the credibility of those witnesses who served our country in combat. This included active duty military personnel and veterans who earned the Purple Heart and Bronze Star, among other battlefield recognition. But President Trump showed utter disregard for such patriotism. For example, President Trump attacked Lieutenant Colonel Vindman during his testimony on November 19th, seeking to question his loyalty to the United States. The President retweeted, Lieutenant Colonel Vindman was offered the position of Defense Minister for the Ukrainian government 3 times. Lieutenant Colonel Vindman, the National Security Director for Ukraine, has been an active duty Army officer for more than 20 years. Lieutenant Colonel Vindman earned a Purple Heart for wounds he sustained in an improvised explosive attack or device in Iraq. President Trump's campaign of witness intimidation is reprehensible, debases the presidency, and was part of his effort to obstruct the impeachment inquiry. The fact that it is the President of the United States making these threats tells us something. It tells us that the President desperately wanted to keep witnesses from testifying and thus further obstruct Congress's inquiry. Senators, we cannot and we must not condone President Trump's attacks on whistleblowers and witnesses, people who truly have the ability to put our country first.
Now that we have carefully reviewed the facts and have described the President's categorical obstruction of Congress, we address questions of law. This discussion need not be abstract. The President's obstruction impacts the Senate directly. It impacts the constituents you represent. It impacts you. Because your job as a member of Congress is to hold the executive branch in check. This is true no matter who occupies the White House or which party controls the House or Senate. And the further the President, any President, departs from the law and the Constitution, the more important it is for you to do your job. I suspect that there is common ground here. We all know that in order for Congress to do its work, we must have information. What is reasonable policy? What is the administration doing? Do we support it? Should we oppose it? Should we enact legislation to correct the problem? Asking questions, gathering information, making decisions based on the answers, this is one of the fundamental functions of Congress. I suspect that we agree on this as well. Our ability to do that work depends on our gathering information. It depends on the power of the congressional subpoena. Even when you make a polite request for information from a friendly administration, that request is backed by the threat of a subpoena. And although the power of the congressional subpoena has been affirmed repeatedly by the courts, enshrined in the rules of the House and Senate, and respected by executive branch agencies for centuries, if the President chooses to ignore our subpoenas, our power as a branch of government, our ability to do our jobs, our ability to keep an administration in check, our ability to make sure that the American people are represented by a Congress and not just by a President, is diminished. Please know that we are not talking about a disagreement over the last few documents at the end of a long production schedule. We are talking about a direct order from the President of the United States to completely disregard all our subpoenas, to deny us all information the President wants to keep secret. This is in order to deprive Congress of our ability to hold an administration accountable. It is a bid to neuter Congress, to render the President all-powerful, since Congress could not have any information the President didn't want us to have. Without information, we cannot act. And so we must ask, is there a consequence for a President who defies our subpoenas absolutely, who says to all branches of the administration, do not obey a single congressional subpoena, categorically, without knowing the subject of the subpoena? Just never answer a congressional subpoena? Who denies Congress the right to any information necessary to challenge his power? Would Madison, Hamilton, and Washington support removing a president who declares that the Constitution lets him do whatever he wants, and who brazenly adds that he can ignore any effort to investigate, even when backed by subpoenas that the law requires him to obey? The answer to all these questions is a resounding yes. But before diving in, I'd like to set the historical scene. The framers were wise, and so they worried that presidents would abuse their power for personal gain. They feared that someday a president might mistake himself for a king, whose decisions cannot be questioned, whose conduct cannot be investigated, whose power transcends the rule of law. Such a would-be king would certainly think things like, quote, I have the right to do whatever I want as president. He might believe that it is, quote, illegitimate for anyone to investigate him. Of course, not even the framers could have imagined that a president would say these things out loud. A president with this view of raw power would attack anyone who tried to hold him to account, branding them, quote, human scum, and, quote, the enemy of the people. He would argue that courts had no power to enforce subpoenas against him. He would conscript his allies to ridicule Congress. He would harass witnesses who testified against him, declaring it disloyal to question his conduct. He would use the powers of his high office to sabotage our system of checks and balances. All of this we have seen in the last few years, indeed in the last few months. The framers wrote the impeachment clause to protect the American people from such a president. The impeachment clause exists to protect our freedom and our democracy in between elections. It exists to remind presidents that they serve the public, not the other way around. It is a reminder to presidents that they answer to something greater than themselves. It confirms that nobody in America is above the law, not even the president. But as we have discussed, the impeachment power does not magically protect us when the president commits high crimes and misdemeanors. In Benjamin Franklin's words, the framers left us a republic, if we can keep it. Now, one way we can uphold that promise is to do our duty as elected members of Congress to hold the executive branch in check. That responsibility is part of the constitutional design. The burden is ours, regardless of our political party, no matter who sits in the Oval Office. In the ordinary course, when we do our jobs, we do our nation a service by holding the executive branch, both its political leadership and its professional core, accountable to the people for its actions. And when the President's conduct exceeds the usual constitutional safeguards, it falls on the House to investigate presidential wrongdoing and, if necessary, to approve articles of impeachment. It then falls on the Senate to judge, convict, and remove presidents who threaten the Constitution. This entire framework depends on Congress' ability to discover and then to thoroughly investigate presidential malfeasance. If presidents could abuse their power and then conceal all the evidence from Congress, the impeachment clause would be a nullity. We, the people, would lose a vital protection. That is why officials throughout history have repeatedly recognized that subpoenas served in an impeachment inquiry must be obeyed, including by the President. It is why, before President Trump, only a single official in American history has ever defied an impeachment subpoena. And that is why that official, Richard Nixon, faced an article of impeachment for doing so. As the House Judiciary Committee reasoned in its analysis of Nixon's obstruction, quote, "Unless the defiance of the House subpoenas is considered grounds for impeachment, it is difficult to conceive of any president acknowledging that he is obligated to supply the relevant evidence necessary for Congress to exercise his constitutional responsibility in an impeachment proceeding." Representative Robert McClory, a Republican from Illinois, explained the importance of this article of impeachment for our separation of powers. He said, "If we refuse to recommend that the President should be impeached because of his defiance of the Congress with respect to the subpoenas that we have issued, the future respondents will be in the position where they can determine themselves what they are going to provide in an impeachment inquiry and what they are not going to provide. And this would be particularly so in the case of an inquiry directed toward the President of the United States. So it not only affects this President, but future presidents. And that's where we find ourselves now, but with even greater force. President Nixon authorized other executive branch officials and agencies to honor their legal obligations. He also turned over many of his own documents. President Trump, in contrast, directed his entire administration, every agency, every office, and every official not to cooperate with the impeachment inquiry. As in Nixon's case, President Trump's obstruction is merely an extension of his cover-up. As in Nixon's case, President Trump's obstruction reveals consciousness of guilt. Innocent people do not act this way. They do not hide all the evidence. And like Nixon, President Trump has offered an assortment of arguments to excuse his obstruction. But as was true in Nixon's case, none of these excuses can succeed. At bottom, these arguments amount to a claim that the President can dictate the terms of his own impeachment inquiry. President Trump's lawyers may insist that his grounds for defying Congress are unique and limited, that they only apply here, just this one time, that it was the House, not the President, that broke from precedent, that he would gladly comply with subpoenas if only the House would do as he insists. That is pure fantasy. The President's arguments are not a one-ride ticket. They are not unique to these facts. Unless they are firmly and finally rejected here, these bogus excuses will reappear every time Congress investigates any president for serious abuses of power. Every single time. They will constitute a playbook for ignoring oversight available to all future presidents, Democratic or Republican. These arguments are not consistent with the Constitution. They are loyally window dressing for an unprecedented, dangerous power grab. Plenty of presidents and judges have complained about impeachment inquiries, declaring their own innocence, attacking the House's motives, and insisting that due process entitled them to all sorts of things. But no president or judge, except Richard Nixon, has ever defied subpoenas on that basis. And no president or judge, none, has ever directed others to defy subpoenas categorically across the board. They have all eventually recognized their obligations under the law. President Trump stands alone. And if President Trump is permitted to defy our subpoenas here in an impeachment inquiry, when the courts have said the congressional power of inquiry is at its highest, imagine what future presidents will do when we attempt to conduct routine oversight. President Trump is the first leader of this nation to declare that nobody can investigate him for official misconduct except on his own terms. In word and in deed, President Trump has declared himself above the law. He has done so because he is guilty and wishes to conceal as much of the evidence from the American people and from this body as he can. In that, he must not succeed. If President Trump is allowed to remain in office after this conduct, historians will mark the date that this Senate allowed this president to break one of our mightiest defenses against tyranny. They will wonder why Congress so readily surrendered one of its core constitutional powers. They will wonder why Congress admitted that a president can get away with anything, can violate any constitutional rule, any liberty, any request for information, and get away with it simply by saying, I don't have to answer your questions. Congress has no power to make me answer questions about my conduct. That's what is at stake. And future people will despair that future presidents can abuse their power without fear of consequence or constraint. Let's begin with a legal premise of the second article of impeachment. Congress has the power to investigate presidents for official misconduct. This premise is indisputable. Article 1 of the Constitution, all legislative powers herein granted shall be vested in the Congress of the United States, which shall consist of a Senate and House of Representatives. Each House may determine the rules of its own proceedings. Our investigations are grounded in Article 1 of the Constitution, which grants Congress all legislative powers and authorizes each House to determine its own rules. As the Supreme Court has explained, the Constitution thus vests the House and the Senate with a power of inquiry that is, and I quote, penetrating and far-reaching, close quote. Moreover, Congress can effectuate that power of inquiry by issuing subpoenas commanding the recipient to provide documents or to testify under oath. Compliance with subpoenas is mandatory. It's not at the option of the executive or the president. As the Supreme Court has explained, quote, it is unquestionably the duty of all citizens to cooperate with the Congress in its efforts to obtain the facts needed for intelligent legislative action. It is their unremitting obligation to respond to subpoenas, to respect the dignity of the Congress and its committees, and to testify with respect to matters within the province of proper investigation. More recently, United States District Judge Ketanji Brown Jackson has elaborated, quote, blatant defiance of Congress' centuries-old power to compel the performance of witnesses is not an abstract injury, nor is it a mere banal insult to our democracy. It is an affront to the mechanism for curbing abuses of power that the framers carefully crafted for our protection, and thereby recalcitrant witnesses actually undermine the broader interests of the people of the United States. In recognition of the important role that congressional inquiries play in protecting our democracy and in guarding the American people, it is unlawful to obstruct them. Of course, while Congress investigates many issues, one of the most important is misconduct in the executive branch. There is a long history of congressional investigations into the executive branch. To name a few especially famous cases, Congress has investigated claims that President Lincoln mishandled Civil War military strategy, the infamous Teapot Dome scandal under President Harding, President Nixon's involvement in the Watergate scandal, President Reagan's involvement in the Iran-Contra affair, President Clinton's real estate dealings in the Monica Lewinsky scandal, warrantless wiretapping under President George Bush, attacks on American personnel in Benghazi under President Obama. Since the dawn of the Republic, presidents have recognized Congress's power to investigate the executive branch. Even in sensitive investigations involving national security and foreign policy, presidents have provided Congress with access to senior officials and important documents. For example, in the Iran-Contra inquiry, President Reagan's former National Security Advisor, Oliver North, and the former Assistant to the President for National Security Affairs, John Poindexter, testified before Congress. President Reagan also produced relevant excerpts of his personal diaries to Congress. During the Clinton administration, Congress obtained testimony from top advisors, including the President's Chief of Staff, Matt McLarty, his Chief of Staff, Erskine Bowles, White House Counsel Bernie Nussbaum, and White House Counsel Jack Quinn. In the Benghazi investigation, President Obama made many of his top aides available for transcribed interviews, including National Security Advisor Susan Rice and Deputy National Security Advisor for Strategic Communications, Benjamin Rhodes. The Obama administration, in that case, also produced more than 75,000 pages of documents, including 1,450 pages of White House emails with communications of senior officials on the National Security Council. To be sure, certain House Republicans complained loudly that the Obama administration's response to the Benghazi investigation was insufficient. Just imagine how they would have reacted if President Obama had ordered total defiance of all subpoenas. There would have been outrage. Why? Because Congress unquestionably has the authority to investigate presidential conduct. Now, not only does Congress have the power to investigate the executive, but as we have discussed, Article 1 of the Constitution gives the House the sole power of impeachment. The framers intended this power to be an essential check on out-of-control presidents. But it does not work automatically. The House must investigate, question witnesses, and review documents. Only then can it decide whether to approve or not approve articles of impeachment. Therefore, when the House determines that the President may have committed high crimes and misdemeanors, it has the constitutional duty to investigate his conduct. In such cases, the House acts not only pursuant to its ordinary legislative authority, but also serves as a grand inquest of the nation. Because an impeachment inquiry wields one of the greatest powers in the Constitution, a power that exists specifically to constrain presidents, its subpoenas are backed with the full force of the impeachment clause. They cannot be thwarted by ordinary executive privileges or ordinary objections. It is therefore presumed, as President Polk conceded over 150 years ago, that, quote, all the archives and papers of the executive departments, public or private, would be subject to inspection, and, quote, every facility in the power of the executive would be afforded to enable the House to prosecute the investigation. What investigation? The impeachment investigation of President Polk. President Polk's statement, which we will return to, was no outlier. Presidents have long understood that they must comply with impeachment inquiries. Consistent with this understanding, in the history of the Republic, no president has ever claimed the unilateral prerogative to categorically defy a House impeachment inquiry. On the contrary, every president facing this issue has agreed that Congress possesses a broad and penetrating power of inquiry when investigating grounds for impeachment. This directly refutes President Trump's claim that he obstructed Congress to protect the office of the President. Every prior occupant of his office has disavowed the limitless power that he asserts. That matters. As the Supreme Court explained just a few years ago, and I quote, long settled and established practice is a consideration of great weight in a proper interpretation of constitutional provisions regulating the relationship between Congress and the President. So let's take a quick tour of the historical record. To begin at the beginning, a sweltering summer in Philadelphia, 1787, the framers discussed at length the balance between presidents and Congress. Remember, they had just fought a bloody war to rid themselves of a tyrant. And they were very conscious they didn't want another tyrant. When impeachment came up, they agreed it would limit the president's authority. But a strong majority of framers saw that as a virtue, not a vice. They wanted to empower the president, but also to keep his power from getting out of hand. Yet impeachment could not serve that role if the House were unable to investigate the president for suspected high crimes and misdemeanors. This was recognized early on, starting with our very first president. In In 1796, the House requested that President Washington provide it with sensitive diplomatic materials relating to the hugely unpopular Jay Treaty with Great Britain. President Washington declined, since this request intruded upon his executive functions. But Washington agreed that impeachment would change his calculus. In the ensuing debates, it was noted on the House floor that Washington had admitted, quote, that where the House expresses an intention to impeach, the right to demand from the executive all papers and information in his possession belongs to it. All papers and information. This was only the first of many references to that point in our constitutional tradition. For example, less than 40 years later, in 1833, Justice Joseph Story remarked upon the dangers of presidential obstruction. He wrote, "The power of impeachment will generally be applied to persons holding high offices under the government, and it is of great consequence that the President should not have the power of preventing a thorough investigation of their own conduct." Consistent with this teaching, President Polk later offered his clear and insightful explanation of why presidents must honor all impeachment subpoenas. As I mentioned just a moment ago, he said, and I quote, "It may be alleged that the power of impeachment belongs to the House of Representatives, and that with a view to the exercise of this power, that House has the right to investigate the conduct of all public officers under the government. This is cheerfully admitted." Decades later, during our first presidential impeachment inquiry, President Andrew Johnson recognized Congress's power to thoroughly investigate him and his executive branch subordinates. In 1867, for example, the House Judiciary Committee obtained executive and presidential records. The committee interviewed cabinet officers and presidential aides about cabinet meetings and private conversations with the president by his top aides and cabinet officials. And multiple witnesses, moreover, answered questions about the opinions of the president, statements made by the president, and advice given to the president. There is no evidence that Johnson ever asserted any privilege to prevent disclosure of presidential conversations to the committee, or failed to comply with any of the committee's requests. Thus, in the first 80 years of the Republic, Presidents Washington, Polk, and Johnson, along with members and committees of the House and a Supreme Court justice, all recognize that Congress is authorized by the Constitution to investigate for impeachment, and that presidents are obligated to give all information requested. President Trump's attempt to stonewall Congress would have shocked those presidents. With only a few exceptions, invocations of the impeachment power subsided from 1868 to 1972. Yet even in that period, while objecting to ordinary legislative oversight, Presidents Ulysses Grant, Grover Cleveland, and Theodore Roosevelt each noted that Congress could obtain key executive branch documents in an impeachment inquiry. They thus confirmed yet again that impeachment is different. Under the Constitution, it requires full compliance. Then came Watergate, when President Nixon abused the powers of his office to undermine his political opponents. But even Nixon understood that he must comply with subpoenas for information relating to his misconduct. Thus, he stated in March 1973 regarding the Senate's Watergate investigation, I quote, "All members of the White House staff will appear voluntarily when requested by the committee. They will testify under oath, and they will answer fully all questions." As a result, many senior White House officials testified, including White House counsel John Dean, White House Chief of Staff H.R. Haldeman, and Deputy Assistant to the President Alexander Butterfield. In addition, Nixon produced many documents in response to congressional subpoenas, including notes from meetings with the President. As the House Judiciary Committee explained at the time, 69 officials had been subjected to impeachment investigations throughout American history. Yet, and I quote, "With the possible exception of one minor official who invoked the privilege against self-incrimination, not one of them challenged the power of the committee conducting the investigation to compel the production of evidence it deemed necessary." President Nixon's production of records was incomplete, however, in a very important respect. He did not produce tape recordings of key Oval Office conversations. In response, the House Judiciary Committee approved an article of impeachment against the President for obstruction of Congress. 24 years later, the House undertook impeachment proceedings against President Clinton. Consistent with President and entirely unlike President Trump, Clinton pledged to cooperate fully with the impeachment investigations. Ultimately, he provided written responses to 81 interrogatories from the Judiciary Committee, and 3 witnesses provided testimony during the Senate trial. As this review of the historical record proves, presidents have long recognized that the Constitution compels them to honor subpoenas served by the House in an impeachment inquiry. Stated simply, President Trump's categorical blockade of the House, his refusal to honor any subpoenas, his order that all subpoenas, without even knowing what they were, all subpoenas be defied, has no analog in the history of the Republic. Nothing even comes close. He has engaged in obstruction that several of his predecessors have expressly said is forbidden, and that led to an article of impeachment against Nixon. President Trump is an outlier. He is the first and only president ever to declare himself unaccountable and to ignore subpoenas backed by the Constitution's impeachment power. If he is not removed from office, if he is permitted to defy the Congress entirely, categorically, to say that subpoenas from Congress in an impeachment inquiry are nonsense, then we will have lost, the House will have lost, the Senate certainly will have lost all power to hold any president accountable. This is a determination by President Trump that he wants to be all-powerful. He does not have to respect the Congress. He does not have to respect the representatives of the people. Only his will goes. He is a dictator. This must not stand, and that is why, another reason, he must be removed from office.
Mr. Chief Justice, Senators, we've now shown how the extreme measures President Trump took to conceal evidence and block witnesses defies the Constitution and centuries of historical practice. But there's more to this story, and it only further undermines President Trump's case. The position he's taken is not only baseless as a historical matter, it's also inconsistent with the Justice Department's stated reason for refusing to indict or prosecute presidents. Now, the Department of Justice's unwillingness to indict a sitting president creates a danger that the president can't be held accountable by anyone, even for grave misconduct. To its credit, the Department of Justice recognized that risk. In its view, quote, the constitutionally specified impeachment process ensures that the immunity would not place the president above the law. This argument by the Justice Department is really important. In justifying its view that a president can't be held criminally liable while in office, DOJ relies on Congress's ability to impeach and remove a president. But the Justice Department's rationale, it falls apart if the constitutionally specified impeachment process can't function because the president himself has obstructed it. The Supreme Court correctly noted in Nixon versus Fitzgerald, and that's not Richard Nixon, it's Judge Nixon, that vigilant oversight by Congress is necessary to, quote, make credible the threat of impeachment. The president should not be treated as immune for criminal liability because he's subject to impeachment, but then be allowed to sabotage the impeachment process itself. That's what this president did. That places him dangerously above the law and beyond the separation of powers. Presidents can't be above the law. Presidents, like everyone else, must obey subpoenas served in an impeachment inquiry. In 1880, the Supreme Court explained, quote, where the question of such impeachment is before either House of Congress, acting in its appropriate sphere on that subject, we see no reason to doubt the right to compel the attendance of witnesses and their answer to proper questions in the same manner and by the use of the same means that courts of justice can in like cases. Almost a century later, Judge John Sirica's influential opinion on the Watergate roadmap in 1974 emphasized the special weight assigned to Congress in an impeachment. He wrote, "It should not be forgotten that we deal in a matter of the most critical moment to the nation, an impeachment investigation involving the President of the United States. It would be difficult to conceive of a more compelling need than that of this country for an unswervingly fair inquiry based on all the pertinent information." That same year, the Supreme Court decided the famous case of Nixon versus the United States. That's President Nixon. I was standing just across the street from the court when the case was handed down. And I remember seeing the reporters running down those marble steps, clutching the court's unanimous decision. The decision forced the release of key Oval Office tapes that President Nixon had tried to cover up by invoking executive privilege. In short order, it led to the resignation of President Nixon. The plaintiff in that case was actually the special prosecutor, Leon Jaworski, who had been appointed to investigate the Watergate burglary and who had issued subpoenas for the Nixon tapes. The Supreme Court upheld these subpoenas against President Nixon's claim of executive privilege. It reasoned that his asserted interest in confidentiality could not overcome the constitutionally grounded interest in the fair administration of criminal justice. Now, in reaching that conclusion, the court said this, quote, "The ends of criminal justice would be defeated if judgments were to be founded on a partial or speculative presentation of the facts. The very integrity of the judicial system and public confidence in the system depend on full disclosure of all facts within the framework of the rules of evidence." That reason, which was a unanimous decision by the Supreme Court in the Nixon tapes case, applies with full force, indeed greater force, to impeachments. The House Judiciary Committee recognized that when it approved an article of impeachment against President Nixon for obstruction of Congress. It reasoned as follows, quote, "If a generalized presidential interest in confidentiality cannot prevail over, quote, the fundamental demand of due process of law in the fair administration of justice, then neither can it be permitted to prevail over the fundamental need to obtain all the relevant facts in the impeachment process. Whatever the limits of legislative power in other contexts, and whatever need may otherwise exist for preserving the confidentiality of presidential conversations, in the context of an impeachment proceeding, the balance was struck in the favor of the power of inquiry. Accordingly, President Trump's conduct is unprecedented and actually offensive to the President's, and it is inconsistent with his duty, his oath, to faithfully execute the laws. Now, that obligation to see that the laws are faithfully executed is not just about enforcing statutes. It's a duty to be faithful to the Constitution, every part of it, as stated in the text and understood across history, and it is a duty he has violated by obstructing Congress here. I want to make one additional point regarding the judiciary. Now, presidents have an obligation to comply with the Congress's impeachment inquiry regardless of whether a court has reviewed the request. We make this point even though I think President Trump's lawyers would be making a mistake to raise it. After all, the President's lawyers can't have it both ways. They can't argue here that we must go to court and then argue in court that our case can't be heard. Anyway, the House's sole power of impeachment wouldn't be sole or much of a power if the House could not investigate the President at all without spending years litigating before the third branch of government. It would frustrate the Constitution for the House to depend entirely on the judiciary to advance its impeachment-related investigatory powers. Consistent with this understanding, before President Trump, the House had never before filed a lawsuit to require testimony or documents in a presidential impeachment. We didn't have to. No president ever issued a blanket ban on compliance with House subpoenas or challenged the House to find a way around his unlawful order. In this strange and unprecedented situation, it's appropriate for Congress to reach its own judgment that the President is obstructing the exercise of its constitutional power. As then Representative Lindsey Graham explained in 1998 during the Clinton proceedings where we served together on the Judiciary Committee, quote, "The day Richard Nixon failed to answer that subpoena is the day he was subject to impeachment because he took the power from Congress over the impeachment process away from Congress, and he became the judge and jury." There's still another reason why it would be wrong and dangerous to insist that the House cannot take action without involving the courts, and that reason is delay. Consider just 3 lawsuits filed by House committees over the past 2 decades to enforce subpoenas against senior executive branch officials. Now, I served on the Judiciary Committee when we decided that we needed to hear from former White House counsel Harriet Miers. In Committee on the Judiciary versus Miers, the Judiciary Committee tried to enforce a subpoena that required her to give testimony about the contentious firing of 9 U.S. attorneys. The committee served the subpoena in 2007. We negotiated, as courts indicate you should, with the White House, and we finally filed suit in March of 2008. We won a favorable district court order in July 2008. But we didn't receive testimony from Miers until June of 2009. That was 2 years. In Committee on Oversight and Reform versus Holder, the Committee on Oversight and Reform tried to force Attorney General Eric Holder to produce additional documents relating to the so-called Operation Fast and Furious. The committee served the subpoena on October 2011. They filed suit August 2012. They won a series of orders requiring productions of documents, but the first such order did not issue until August of 2014, nearly 3 years. In Committee on the Judiciary versus McGahn, the House Judiciary Committee sought to enforce a subpoena to require White House counsel Don McGahn to give testimony regarding matters relating to the special counsel's investigation. Now, we served that subpoena in April of last year. We filed suit in August of last year. We won a favorable district court order in November of last year. The Court of Appeals has stayed that ruling and didn't hear arguments until early this month with an opinion and potentially, unlikely, Supreme Court application likely to follow. We will not have an answer likely this year. Sometimes courts move quickly, but here they haven't, not at all. Even when the House urges expedited action, it usually takes years, not months, to get evidence through judicial proceedings. Now, the President can't put off impeachment for years by ordering total defiance of the House and then insist the court go to court even as he argues that they can't go to court. That's especially true where the President doesn't just raise 1 or 2 objections to specific subpoenas, but orders a blanket, government-wide cover-up of all evidence. That kind of order makes this clear. The President sees himself completely immune from any accountability, above the law. It reveals his pretensions, really, to absolute power. It confirms he must be removed from office. Now, here's the key point. President Trump's obstruction of Congress is not merely unprecedented and wrong, it's also a high crime and misdemeanor, as the framers used and understood that phrase, warranting his immediate removal from office. To see why, let's return to first principles. As the framers deliberated in Philadelphia, George Mason posed a profound question. Shall any man be above justice? That question wasn't a hypothetical. The framers had just rebelled against England, where one man, the king, was in fact above justice. By authorizing Congress to remove presidents from egregious misconduct, the framers rejected that model. Unlike Britain's king, the president would answer to Congress and thus to the nation if he engaged in serious wrongdoing, because the impeachment power exists not to punish the president, but to check presidents. It can't function if presidents are free to ignore all congressional investigation and oversight. An impeachment scholar, Frank Bowman, said this: without the power to compel compliance with subpoenas and the concomitant right to impeach a president for refusal to comply, the impeachment power would be nullified. So the consequences of presidential obstruction go beyond any particular impeachment inquiry. They go to the heart of the impeachment power itself. They weaken our shield against a dangerous or corrupt president. Now, of course, presidents are still free to raise privacy, national security, or other concerns in the course of an impeachment inquiry. There's room for good faith negotiations over what evidence will be disclosed. Although there is a strong presumption in favor of full compliance with congressional subpoenas. But when a president abuses his office, abuses his power to completely defy House investigators in impeachment inquiry, when he does that without lawful cause or excuse, he attacks the Constitution itself. When he does that, he confirms that he sees himself as above the law. President Nixon's case is informative. As noted, President Nixon let his senior officials testify. He produced many documents. He did not direct anything like a blanket, indiscriminate block of the House's impeachment inquiry. He still did defy subpoenas seeking records and recordings of the Oval Office. Now, President Nixon claimed that his noncompliance was legally defensible. He invoked the doctrine of executive privilege. The Judiciary Committee rejected that excuse. The committee emphasized that, quote, the doctrine of separation of powers cannot justify the withholding of information from an impeachment inquiry. After all, the very purpose of such an inquiry is to permit the House, acting on behalf of the people, to curb the excesses of another branch, in this instance, the executive. Quote, whatever the limits of legislative power in other contexts, and whatever need may otherwise exist for preserving the confidentiality of presidential conversations in the context of an impeachment proceeding, the balance was struck in favor of the power of inquiry when the impeachment provision was written into the Constitution. Now, ultimately, the committee approved an article against Nixon because he sought to prevent the House from exercising its constitutional duty. Article 3 charged Nixon with abusing his power by interfering with the discharge of the Judiciary Committee's responsibility to investigate fully and completely whether he had committed high crimes and misdemeanors. President Nixon's third article of impeachment explained it this way, quote, "In refusing to produce these papers and things, Richard M. Nixon, substituting his judgment as to what materials were necessary for the inquiry, interposed the powers of the presidency against the lawful subpoenas of the House of Representatives, thereby assuming to himself functions and judgments necessary to the exercise of the sole power of impeachment as vested by the Constitution and the House of Representatives. In all of this, Richard M. Nixon acted contrary, in a matter contrary to his trust as President, subversive constitutional government, to the great prejudice of the cause of law and justice, and to the manifest injury of the people of the United States." President Nixon's case powerfully supports the conclusion that presidential defiance of the House impeachment inquiry constitutes high crimes and misdemeanors. You know, I've been thinking a lot about the founders. I've been rereading the Constitution and the notes from the Constitutional Convention. It was just a little over 230 years ago that they met in Philadelphia, not too far from here. They'd been at it for a long time. They didn't know whether the Constitution they were trying to write would sustain freedom, but they were trying to create a completely different type of government. On July 20th, Governor Morris said this, "The magistrate is not the king. The people are the king." George Mason of Virginia, on that same day, said, "Shall any man be above justice? Above all, that man may be above it who can commit the most extensive injustice." And Eldridge Gerry argued that he hoped that the maxim that the chief magistrate could do no wrong would never be adopted here. Now, finally, on September 8th, they adopted the impeachment clause in the U.S. Constitution. But I hope that we will remember the admonition that we should never accept the fact that the magistrate, the president, can do no wrong. They crafted a Constitution to protect our liberty and the liberty of those who will follow us. Professor Noah Feldman talked about the Constitution in his testimony before the House.
A president who says, as this president did say, "I will not cooperate in any way, shape, or form with your process," robs a coordinate branch of government. He robs the House of Representatives of its basic constitutional power of impeachment.
You know, a president who does that also endangers the American people by stripping away the Constitution's final safeguard against presidents who abuse power and harm the nation. Such a president acts like a king, which the founders were fighting against. That's what they wrote out of the Constitution. A president cannot be immune from oversight, accountability, and even simple justice in the exercise of the powers entrusted to him. We can't let that stand in this case. The president must forfeit the powers that he's abused and be removed from office.
Mr. Chief Justice, distinguished members of the Senate, counsel for the President, my colleagues, the American people who are assembled here today. I think we have our next break scheduled for within the hour. And so I find myself in the unenviable position of being the only thing standing between you and our dinner. But be not discouraged, because I'm going to try to follow the advice of a former Sunday school teacher of mine, grew up in the Cornerstone Baptist Church in Brooklyn. She said, Jeffries, on the question of public presentations, be brief, be bright, and be gone. And so I'm going to try to do my best. Presidents are required to comply with impeachment subpoenas. This president has completely defied them. That conduct alone is a high crime and misdemeanor. The facts here are not really in dispute. President Trump's defense appears to be, I can do whatever I want to do. Only I can fix it. I am the chosen one.
Then I have an Article 2 where I have the right to do whatever I want as president. Nobody knows the system better than me. Which is why I alone can fix it. Somebody had to do it. I am the chosen one. Somebody had to do it.
Is that who we are as a democracy? President Trump can't address the substance of our case. He therefore complains about process. But these procedural complaints are baseless excuses, and they do not justify his attempts to hide the truth from Congress and from the American people. The president's arguments fail for 4 simple reasons. First, the House, not the president, has the sole power of impeachment and the sole power to determine the rules of its proceedings. That's Article 1, Section 2 of the Constitution. Second, President Trump's due process argument has no basis in law, no basis in fact, no basis in the Constitution. President Trump may not preemptively deny any and all cooperation to the House and then assert that the House's procedures are illegitimate because they lack his cooperation. Third, President Trump's claim that he is being treated differently completely lacks merit. Despite what he contends, the House provided President Trump with greater protection than what was given to both President Nixon and President Clinton. The fact that President Trump failed to take advantage of these procedural protections does not mean they did not exist. President Trump is not the first president to complain about House procedures. He won't be the last. He's not the first one to challenge the motives of any investigation or certainly an impeachment inquiry. Such complaints are standard operating procedure from the Article 2 executive branch. Presidents Johnson, President Nixon, President Clinton had plenty of complaints. But no president has treated such objections as a basis for withholding evidence, let alone categorically defying every single subpoena. None, except Donald John Trump. Finally, the obligation to comply with an impeachment subpoena is unyielding. It does not dissipate because the president believes House committees should invite different witnesses, give his defenders unfettered subpoena power, or involve his personal lawyers at the deposition stage of the process when that has never been done. And if a president can defy Congress on such fragile grounds, then it is difficult to imagine why any future president would ever comply with an impeachment or investigative subpoena again. Now, throughout our history, impeachments have been rare, and the Supreme Court has made clear that it's wary of intruding on matters of impeachment. This, of course, leaves room for inter-branch negotiation, but it does not allow the President to engage in blanket defiance. President Trump's objections are not genuinely rooted in the law. They are not good faith legal arguments. We know that because President Trump said early on he would fight all subpoenas. We know that because he declared the impeachment inquiry illegitimate before it even adopted any procedures. We know that because he has denounced every single effort to investigate him as a witch hunt. And we know that because he never even claimed executive privilege during the entire impeachment proceeding. President Trump's first excuse for obstructing Congress is his asserted belief that he did nothing wrong, that his July 25th call with President Zelensky was perfect. In the October 8th letter sent by his counsel, President Trump asserted the prerogative to defy all House subpoenas because he has declared his own innocence. As Mr. Cipollone put it, at President Trump's behest, the President did nothing wrong, and there is no basis for an impeachment inquiry. He had the White House counsel include this in a formal letter to the House, defying every single subpoena. As we have shown in our discussion of the first article of impeachment, these claims of innocence are baseless. They lack merit. We have provided overwhelming evidence of President Trump's guilt. The President cannot lawfully obstruct the House impeachment inquiry because he sees no need to be investigated. One of the most sacred principles of justice is that no man should be the judge in his own case. And yet, that is exactly what President Trump has been determined to do. But this is America. He cannot be judge, jury, and executioner. Moreover, the President cannot simply claim innocence and then walk away from a constitutionally mandated process. Even President Nixon did not do that, as we have previously established. Congress has a constitutional responsibility to serve as a check and balance on an out-of-control executive branch. Our responsibility is not to this President, it is to the American people. Blanket presidential defiance would bring a swift halt to all congressional oversight of the executive. That principle would have authorized categorical obstruction in the impeachments of President Johnson, President Nixon, and President Clinton. In each of those cases, the House was controlled by a different party than the presidency. And the President attacked those inquiries as partisan. Yet those presidents did not view their concerns with excessive partisanship as a basis for defying every single subpoena. The purpose of an impeachment inquiry is for the House to collect evidence to determine on behalf of the American people whether the President may have committed an impeachable offense, because the Constitution vests the House with the sole power of impeachment. The President who serves as the judge of his own innocence is not acting as a president. That's a dictator. That's a despot. That is not democracy. The President also believes, it appears, that his blanket obstruction was justified because the House did not expressly adopt a resolution authorizing an impeachment inquiry or properly delegate such investigative powers to its committees. Now, the full House voted in January in advance of the inquiry, to adopt rules authorizing committees to conduct investigations, issue subpoenas, gather documents, and hear testimony. Beginning in the spring and summer of 2019, evidence came to light that President Trump and his associates might have been seeking the assistance of another foreign government, Ukraine, to influence the upcoming 2020 election. On September 9th, the House investigating committees announced they were launching a joint investigation. They requested records from the White House and the Department of State. This investigation was consistent with all rules approved by the full House. At the same time, evidence emerged that the President may have attempted to cover up his actions and prevent the transmission of a whistleblower complaint to the Intelligence Committee of the Senate and the House. Given the gravity of these allegations and the immediacy of the threat to the next presidential election, the Speaker of the House, a constitutional officer, explicitly named in Article 1, announced on September 24th that the House would begin a formal impeachment inquiry. There is nothing in the Constitution, nothing in federal law, nothing in Supreme Court jurisprudence that required a formal vote at the time. The President has put forth fake arguments about process because he cannot defend the substance of these allegations. Following the announcement of the impeachment inquiry, the House investigating committees issued additional requests and then subpoenas for documents and testimony. The committees made clear that this information would be collected as part of the House's impeachment inquiry and shared among committees, as well as with the Committee on the Judiciary as appropriate. Then, on October 31st, the full House voted to approve House Resolution 660, which directed the House committees to continue their ongoing investigations as part of the existing inquiry into whether sufficient grounds exist for the House of Representatives to exercise its constitutional power to impeach Donald John Trump. In addition to affirming the ongoing House impeachment inquiry, H.Res. 660 set forth procedures for open hearings in the Intelligence Committee and for additional proceedings in the Judiciary Committee. Every step in this process was fully consistent with the Constitution, the rules of the House, and House precedent. The House's autonomy to structure its own proceedings for an impeachment inquiry is grounded in the Constitution. The President's principal argument to the contrary is that no committee of the House was permitted to investigate any presidential misconduct until the full House acted. As a federal district court recently confirmed, the notion that a full House vote is required to authorize an impeachment inquiry has no textual support in the U.S. Constitution or the governing rules of the House. The investigations into misconduct by Presidents Andrew Johnson, Nixon, and Clinton all began prior to the House's consideration and approval of a resolution authorizing the investigation. Recently, under Republican control, the Judiciary Committee considered the impeachment of the Commissioner of the Internal Revenue Service, following a referral from another committee and absent a full vote of the House for an impeachment inquiry. There is no merit to President Trump's argument that the full House had to vote. The sequence of events in this particular case largely tracked those in the Nixon proceedings. The House Judiciary's proceedings began in October of 1973, when resolutions calling for President Nixon's impeachment were introduced in the House and referred to the Judiciary Committee. Over the next several months, the committee investigated the Watergate break-in and cover-up, among other matters, using its existing investigatory authority. The committee also hired a special counsel and other attorneys to assist in these efforts. Most importantly, all of this occurred before the House approved a resolution directing the Judiciary Committee to investigate whether grounds to impeach Richard Nixon existed. In this instance, the committees began the investigation with their existing powers, authorized by the full House. That course of events is entirely consistent with the Richard Nixon precedent. It is also common sense. After all, before voting to conduct an impeachment inquiry, the House must ascertain the nature and seriousness of the allegations and the scope of the inquiry that may follow thereafter. President Trump's second excuse also fails. Let's now address the President's so-called due process and fairness arguments. The President has phrased some of his complaints in the language of due process. He has complained that the procedures were not fair, even though they reflect prior practice and strike a reasonable balance between presidential involvement on the one hand and the House's obligation to find the truth on the other. Presidents come and presidents go. They have all sharply criticized House procedures, but no president has ever treated those objections as a basis for complete defiance. No president has ever done that. In the context of a House impeachment inquiry, it's fair to say that a president is a suspect who may have committed a high crime or misdemeanor. He cannot tell the detectives investigating the possible constitutional crime what they should do in the context of their investigation. In the President's October 8th letter, Mr. Cipollone complains that he was denied the most basic protections demanded by due process under the Constitution and by fundamental fairness, including the right to cross-examine witnesses, to call witnesses, to receive transcripts of testimony, to have access to evidence, and to have counsel present. It sounds terrible, but it's not accurate. The President appears to have mistaken the initial phases of the impeachment inquiry for a full-blown trial. The trial phase of the impeachment inquiry is taking place right now. Chairman Peter Rodino of the Judiciary Committee once observed, as it relates to the impeachment proceedings against President Nixon, it is not a right, but a privilege or a courtesy for the President to participate through counsel. An impeachment inquiry is not a trial. Rather, it entails a collection and evaluation of facts before the trial occurs. In that respect, the House acts like a grand jury or a prosecutor investigating the evidence to determine whether charges are warranted or not. Federal grand juries and prosecutors do not allow targets of their investigation to coordinate witness testimony. The protections that the President label as due process do not apply here. Because those entitlements that he sought, many of which were actually afforded to him, but those entitlements that he sought would not necessarily be available to any American in a grand jury investigation. Moreover, it should be clear that the House, notwithstanding this framework, has typically provided a level of transparency in impeachment inquiries particularly as it relates to presidents. In past impeachment inquiries, this has typically meant that the principal evidence relied upon by the House Judiciary Committee is disclosed to the President and to the public, though some evidence in past proceedings has actually remained confidential. The President has typically been given an opportunity to participate in the proceedings at a stage when evidence has been fully gathered and presented to the Judiciary Committee. President Trump was given the chance to do that in this case, but he declined. Presidents have been entitled to present evidence that is relevant to the inquiry and to request that relevant witnesses be called. President Trump was given the chance to do that in the House impeachment inquiry before the Judiciary Committee, but he declined. Under House Resolution 660, President Trump received procedural protections not just equal to, but in some instances greater than that afforded to Presidents Nixon and Clinton. So let's be clear. The privileges described in the October 8th letter were in fact offered to President Trump, as they had been in prior impeachment inquiries. The President was able to review all evidence relied on by the House investigating committees, including evidence that the minority's public report identified as favorable to President Trump. During the Judiciary Committee proceedings, the President had opportunities to present evidence, call witnesses, have counsel present to raise objections, cross-examine witnesses, and respond to the evidence raised against them. As the Rules Committee report accompanying House Resolution 660 noted, these privileges are commensurate with the inquiry process followed in the cases of Nixon and Clinton. President Trump simply chose not to avail himself of what had been offered. The fact that President Trump declined to take advantage of these protections does not excuse his blanket unconstitutional obstruction. Unlike the Nixon and Clinton impeachments, in this particular instance, the argument that the President has made, the argument that he has made as it relates to the investigative process is not analogous. In this case, the House conducted a significant portion of the factual investigation itself because no independent prosecutor was appointed to investigate the allegations of wrongdoing against President Trump. Attorney General William Barr refused to authorize a criminal investigation into the serious allegations of misconduct against the President. They tried to whitewash the whole sordid affair. Left to their own devices, the House investigative committees followed standard best practices for investigations, consistent with the law enforcement investigations into Presidents Nixon and Clinton in advance of their impeachments. The committees released transcripts of all interviews and depositions conducted during the investigation. During the investigation, more than 100 members of the House participated in the so-called closed-door proceedings. More than 100 members of the House, 47 of whom were Republicans. They all had the opportunity to ask questions. They all had the opportunity to ask questions with equal time. The Intelligence Committee held public hearings where 12 of the key witnesses testified, including several requested by the House Republicans. It is important to note that the very same procedures in House Resolution 660 were supported by Acting White House Chief of Staff Mick Mulvaney when he served as a member of the Oversight Committee, and by the Secretary of State, Mike Pompeo, when he served as a member of the Select Committee on Benghazi.
Tell you in the private interviews, there is never any of what you saw Thursday. It is 1 hour on the Republican side, 1 hour on the Democrat side, which is why you're going to see the next 24 interviews done privately, because it is, I mean, look at the other investigations that are being done right now. The Lois Lerner investigation that was just announced, was that public or private?
If this process was good enough for other presidents, why isn't it good enough for President Trump? Representative Gowdy finished that statement by saying, "The private ones have always produced the best results." The private ones, according to Trey Gowdy, have always produced the best results. President Trump complained that his counsel was not afforded the opportunity to participate during the Intel Committee's proceedings. But neither President Nixon nor President Clinton were permitted to have counsel participate in the initial fact-gathering stages when they were investigated by special counsel, independent counsel. President Nixon certainly had no attorney present when the prosecutors and grand juries began collecting evidence about Watergate and related matters. President Nixon did not have an attorney present in this distinguished body when the Senate Select Committee on Watergate began interviewing witnesses and holding public hearings. Nor did President Clinton have an attorney present when prosecutors from the Office of Independent Counsel Kenneth Starr deposed witnesses and elicited their testimony before a grand jury. President Trump's attorney could have cross-examined the Intel Committee's counsel during his presentation of evidence before the House Judiciary Committee. That would have functioned as the equivalent opportunity afforded to President Clinton to have his counsel cross-examine Kenneth Starr, which he did at length. President Trump was provided a level of transparency and the opportunity to participate consistent with the highest standards of due process and fairness given to other presidents who found themselves in the midst of an impeachment inquiry. The President, and I'm winding down, the President's next procedural complaint is that it was unconstitutional to exclude agency counsel from participating in congressional depositions. The basis for the rule excluding agency counsel is straightforward. It prevents agency officials who are directly implicated in the abuses Congress is investigating from trying to prevent their own employees from coming forward to tell Congress and the American people the truth. It's common sense. The rule protects the rights of witnesses by allowing them to be accompanied in depositions by personal counsel, a right that was afforded to all of the witnesses who appeared in this matter. Agency attorneys have been excluded from congressional depositions of executive branch officials for decades under both Republicans and Democrats, including Republican Chairman Dan Burton, Republican Chairman Darrell Issa, Republican Chairman Jason Chaffetz, Republican Chairman Trey Gowdy, Republican Chairman Kevin Brady, and Republican Chairman Jeb Hensarling, just to name a few. Again, the Constitution provides the House with the sole power of impeachment and the sole authority to determine the rules of its proceedings, which were fair to all involved. Given the Constitution's clarity on this point, the President's argument that he can engage in blanket obstruction is just dead wrong. President Trump also objects that the House minority lacks sufficient subpoena rights. But the subpoena rules that were applied in the Trump impeachment inquiry were put into place by my good friends and colleagues on the other side of the aisle, House Republicans, when they were in the majority. We are playing by the same rules devised by our Republican colleagues. President Nixon did not engage in blanket obstruction. President Clinton did not engage in blanket obstruction. No president of the United States has ever acted this way. Lastly, we should reject President Trump's suggestion that he can conceal all evidence of misconduct based on unspecified confidentiality interests. Those are his exact words, confidentiality interests. But not once in the entire impeachment inquiry did he ever actually invoke executive privilege. Perhaps that's because executive privilege cannot be invoked to conceal evidence of wrongdoing. Perhaps that's because executive privilege does not permit blanket obstruction that includes blocking documents and witnesses from the entire executive branch. Perhaps President Trump didn't invoke executive privilege because it has never been accepted as a sufficient basis for completely and totally defying all impeachment inquiries and subpoenas. Or perhaps President Trump didn't invoke executive privilege because when President Nixon did so, he lost decisively, unanimously, clearly before the Supreme Court. Whatever the explanation, President Trump never invoked executive privilege, so it is not a credible defense to his obstruction of Congress. President Trump has lastly suggested that his obstruction is justified because his top aides are absolutely immune from being compelled to testify before Congress. Every federal court to consider the so-called doctrine of absolute immunity has rejected it. In 2008, a federal court rejected an assertion by the 43rd President of the United States that White House counsel Harriet Miers was immune from being compelled to testify, noting that the President had failed to point to a single judicial opinion to justify that claim. And on November 25th of last year, another federal judge rejected President Trump's claim of absolute immunity for former White House counsel Don McGahn. The court concluded executive branch officials are not absolutely immune from compulsory congressional process, no matter how many times the executive branch has asserted as much over the years, even if the President expressly directs such officials not to comply. The court added, simply stated, the primary takeaway from the past 250 some odd years of recorded American history is that presidents are not kings. The President is not a king. President Trump tried to cheat. He got caught. And then he worked hard to cover it up. He must be held accountable for abusing his power. He must be held accountable for obstructing Congress. He must be held accountable for breaking his promise to the American people.
My foreign policy will always put the interests of the American people and American security above all else. Has to be first. Has to be. That will be the foundation of every single decision that I will make.
What does it mean to put America first? America is a great country, but above all else, I think America is an idea, a precious idea, an idea that has withstood the test of time, an enduring idea. Year after year, decade after decade, century after century, as we continue our long, necessary, and majestic march toward a more perfect union. America is an idea. One person, one vote. Liberty and justice for all. Equal protection under the law. Government of the people, by the people, and for the people. The preeminence of the rule of law. America is an idea. We can either defend that idea or we can abandon it. God help us all if we choose to abandon it.
Majority Leader is recognized.
Mr. Chief Justice, we'll take a 30-minute break for dinner.
Without objection, so ordered.
Will come to order. The majority leader is recognized.
I've spoken with Congressman Schiff and his team, and it looks like we've got a couple more hours.
Okay.
Mr. Chief Justice, members of the Senate, counsel for the President, impeachment exists not to inflict personal punishment for past wrongdoing, but rather to protect against future presidential misconduct that would endanger democracy and the rule of law. President Trump remains a threat in at least three fundamental ways. First, he continues to assert in court and elsewhere that nobody in the U.S. government can investigate him for wrongdoing, making him unaccountable. Second, his conduct here is not a one-off. It's a pattern of soliciting foreign interference in our elections to his own advantage, and then using the powers of his office to stop anyone who dares investigate. Finally, the President's obstruction is very much a constitutional crime in progress, harming Congress as it deliberates these very proceedings and the American people who deserve to know the facts. A President who believes he can get away with anything and can use his office to conceal evidence of abuse threatens us all. President Trump is the first president in U.S. history to say he is immune from any effort to examine his conduct or check his power. He claims he is completely immune from criminal indictment and prosecution while serving as president. He claims he could commit any crime, even shoot someone on Fifth Avenue, as he has joked about, with impunity. And the president's own lawyers have argued in court that he cannot even be investigated for violating the law under any circumstance. Now, no president of either party has ever made claims like this. And if in an investigation somehow does uncover misconduct by the president, as this investigation has done, the president believes that he can simply quash it. He claims the right to end federal law enforcement investigations for any reason or none at all, even when there is credible evidence of his own wrongdoing. Added together, the president's positions amount to a license to do anything he wants. No court has ever accepted this view, and for good reason. Our founders created a system in which all people, even presidents, are bound by the law and accountable for their actions. In addition to claiming that he is immune from criminal process, President Trump contends that he is not accountable to either Congress or the judiciary. He has invoked bizarre legal theories to justify defying congressional investigations. He has argued that Congress is forbidden from having the courts intervene with executive branch officials disregarding its subpoenas. He has sued to block third parties from complying with congressional subpoenas. And perhaps most remarkably, President Trump has claimed that Congress cannot investigate his misconduct outside of an impeachment inquiry, while simultaneously claiming that Congress cannot investigate his misconduct in an impeachment inquiry. Of course, President Trump considers any inquiry to be illegitimate if he thinks he did nothing wrong, doubts the motives of Congress, or decides that he would prefer a different set of rules. Let's review the president's position. He can't be investigated for crimes. He can end any federal law enforcement investigation into him. He is immune from any state law enforcement investigation. Neither he nor his aides can be subpoenaed. He can reject subpoenas based on broad, novel, and even rejected theories. And when he does reject subpoenas, Congress is not allowed to sue him. But he is allowed to sue to block others from complying with congressional subpoenas. Congress definitely can't investigate him outside of an impeachment inquiry, and again, it can't investigate him as part of one. The bottom line is that the President truly believes that he is above the law. This is not our system, and it never has been. The President is a constitutional officer. Unlike a king, he is accountable to the Constitution. But this President doesn't believe that, and that's why we are here. Remember, the precedent that you set in this trial will shape American democracy for the future. It will govern this President, and it will govern those who follow. If you let the President get away with his obstruction, you risk grave and irreparable harm to the separation of powers itself. Representative Lawrence Hogan, a Republican from Maryland, made this point during the Nixon impeachment hearings.
The historical precedent we're setting here is so great because in every future impeachment of a president, it is inconceivable that the evidence relating to that impeachment will not be in the hands of the executive branch, which is under his controls. So I agree with the gentleman from Ohio, Mr. Seiberling. If we do not pass this article today, the whole impeachment power becomes meaningless.
This leads us to a second consideration: the President's pattern of obstructing. Article 2 describes President Trump's impeachable conduct in obstructing Congress. On its own, that warrants removal from office. Yet it must be noted that the President's obstruction fits a disturbing pattern. As stated in Article 2, President Trump's obstruction is, quote, consistent with his previous efforts to undermine United States government investigations into foreign interference in United States elections. Another example is President Trump's attempts to impede the special counsel's investigation into Russian interference with the 2016 election, as well as the President's sustained efforts to obstruct the special counsel after learning that he was under investigation for obstruction of justice. The special counsel's investigation addressed an issue of extraordinary importance to our national security and democracy: the integrity of our elections themselves. Rather than aid the special counsel's investigation, however, President Trump sought to thwart it and used the powers of his office to do it. After learning that he himself was under investigation, President Trump ordered the firing of the special counsel, sought to curtail the special counsel's investigation, instructed the White House counsel to create a false record and make false public statements, and tampered with at least 2 key witnesses in the investigation. The pattern is as unmistakable as it is unnerving. In one moment, President Trump welcomed and invited a foreign nation to interfere in an election to his advantage. In the next, he solicited and pressured a foreign nation to do so. In one moment, President Trump used the powers of his office to obstruct the special counsel. In the next, he used the powers of his office to obstruct the House impeachment inquiry. In one moment, the President stated that he remained free to invite foreign interference in our elections. And the next, he in fact invited additional foreign interference in our elections.
And by the way, likewise, China should start an investigation into the Bidens.
Indeed, President Trump placed his fateful July 25th call to President Zelensky just one day after the special counsel testified in Congress about his findings. As Professor Gerhardt testified before the Judiciary Committee, quote, "The power to impeach includes the power to investigate. But if the President can stymie this House's impeachment inquiry, he can eliminate the impeachment power as a means for holding him and future presidents accountable for serious misconduct. If left unchecked, the President will likely continue his pattern of soliciting foreign interference on his behalf in the next election. Now, I must emphasize that President Trump's obstruction persists to this day. The second article of impeachment charges a high crime in progress. As a result, the President's wrongdoing did not just harm the House as we have performed our own constitutional duty, it is also harming the Senate, which is being deprived of information you need before the votes you will soon take. And of course, the true victim is the American people, who deserve the full truth. As we've discussed, the President's claims that all the evidence he is hiding and covering up would actually prove his innocence. To borrow a phrase from the late Justice Scalia, that claim, quote, taxes the credulity of the credulous. President Trump has used all the authority of his office to block the full truth from coming to light. He has defied subpoenas and ordered others to do so. He has publicly intimidated and threatened witnesses. He has attacked the House for daring to investigate him. And he has lobbed an endless volley of personal attacks on witnesses and meritless complaints about procedure to sow confusion and distract the American people. The President's abuses are unfolding before our eyes, and they must be stopped. Now, before I conclude, I think you all deserve an explanation from me as to why I am standing here. There's been a lot of conversation the last few years about what makes America great. And I have some ideas about that. I happen to think that what makes America great is that generation after generation, there have been Americans that have been willing to stand up and put aside their self-interest to make great sacrifices for the public good, for our country. I know because I have seen people do that. Like some of the people in this chamber, I have seen people give everything for this country so we could sit here today. Now, this isn't politically expedient. It certainly isn't for me. It's hard. It requires sacrifice. It's uncomfortable. But that is the very definition of public service. That we are here to give of ourselves for the country, for others, at sacrifice to ourselves. Those who have given so much for this country deserve nothing less from us now than to try to honor those sacrifices. I have tried to do that the last few days. My time is done, and it is now your turn.
Chief Justice, Senators, learned counsel for the President, you'll be pleased to know this is the last presentation of the evening. And as I started last night, I made reference to some good advice I got from an encouraging voice that said, keep it up but not too long. Tonight I got some equally good advice. To be immortal, you don't need to be eternal. And I will do my best not to be eternal. First point I'd like to make is I'm tired. I don't know about you, but I'm exhausted.
and I can only imagine how you feel. But I'm also very deeply grateful for just how you have attended to these presentations and discussions over the last few days. I'm deeply grateful. I can tell how much consideration you've given to our point of view and the President's point of view, and that's all we can ask. At the end of the day, all we can ask is that you hear us out and make the best judgment that you can, consistent with your conscience and our Constitution. Now, I wanted to start out tonight with where we began, when we first appeared before you about a week ago, and that is with the resolution itself, with what the President is charged with in the articles and how that holds up now that you have heard the evidence from the House. Donald Trump was impeached in Article 1 for abuse of power. And that article provides that in his conduct of the office of President of the United States and in violation of his constitutional oath faithfully to execute the office of President of the United States and to the best of his ability preserve, protect, and defend the Constitution of the United States, and is in violation of his constitutional duty to take care that the laws be faithfully executed, Donald J. Trump has abused the powers of his presidency in that, using the powers of his high office, President Trump solicited the interference of a foreign government, Ukraine, in the 2020 United States presidential election. President Trump solicited the interference of a foreign government, Ukraine, in the 2020 election. That has been proved. He did so through a scheme or course of conduct that included soliciting the government of Ukraine to publicly announce investigations that would benefit his reelection, harm the election prospects of a political opponent, and influence the 2020 U.S. presidential election to his advantage. That has been proved. President Trump also sought to pressure the government of Ukraine to take these steps by conditioning official U.S. government acts of significant value to Ukraine on its public announcement of the investigations. That has been proved. President Trump engaged in the scheme or course of conduct for corrupt purposes in pursuit of personal political benefit. That has been proved. In doing so, President Trump used the power of the presidency in a manner that compromised the national security of the United States and undermined the integrity of the United States democratic process. That has been proved. He thus ignored and injured the interests of the nation. That has been proved. President Trump engaged in this scheme or course of conduct through the following means. President Trump, acting both directly and through his agents within and outside the United States government, corruptly solicited the government of Ukraine to publicly announce investigations into a political opponent, former Vice President Joseph R. Biden, Jr. That has been proved. A discredited theory promoted by Russia alleging that Ukraine, rather than Russia, interfered in the 2016 United States presidential election. That has been proved. With the same corrupt motives, President Trump, acting both directly and through his agents within and outside the U.S. government, conditioned two official acts on the public announcements that he had requested: the release of $391 million of U.S. taxpayer funds that Congress had appropriated on a bipartisan basis for the purpose of providing vital military and security assistance to Ukraine to oppose Russian aggression, and which President Trump had ordered suspended. That has been proved. And B, a head-of-state meeting at the White House, which the President of Ukraine sought to demonstrate continued United States support for the government of Ukraine in the face of Russian aggression. That has been proved. Faced with public revelation of his actions, President Trump ultimately released the military and security assistance to the government of Ukraine, but has persisted in openly and corruptly urging and soliciting Ukraine to undertake investigations for his personal political benefit. That has been proved. These actions were consistent with President Trump's previous invitations of foreign interference in U.S. elections. That has been proved. In all of this, President Trump abused the powers of the presidency by ignoring and injuring national security and other vital national interests to obtain an improper personal political benefit. That has been proved. He also betrayed the nation by abusing his high office to enlist a foreign power in corrupting democratic elections. That has been proved. Wherefore, President Trump, by such conduct, has demonstrated that he will remain a threat to national security and the Constitution if allowed to remain in office, and has acted in a manner grossly incompatible with self-governance and the rule of law. That has been proved. President Trump thus warrants impeachment and trial, removal from office, and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. That will be for you to decide. But the facts have been proved. Those facts are not contested. We have met our burden. Article 2, obstruction of Congress. The Constitution provides that the House of Representatives shall have the sole power of impeachment, and the President shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. In his conduct of the office of the President, in violation of his constitutional oath, faithfully to execute the office of President of the United States, and to the best of his ability, preserve, protect, and defend the Constitution of the United States, and in violation of his constitutional duty to take care that the laws be faithfully executed, Donald J. Trump has directed the unprecedented, categorical, and indiscriminate defiance of subpoenas issued by the House of Representatives pursuant to its sole power of impeachment. That has been proved. President Trump has abused the powers of the presidency in a manner offensive to and subversive of the Constitution, in that the House of Representatives has engaged in an impeachment inquiry focused on President Trump's corrupt solicitation of the government of Ukraine to interfere in the 2020 U.S. presidential election. That has been proved. As part of this impeachment inquiry, the committees undertaking the investigation served subpoenas, seeking documents and testimony deemed vital to the inquiry from various executive branch agencies and offices and current and former officials. That has been proved. In response, without lawful cause or excuse, President Trump directed executive branch agencies, offices, and officials not to comply with those subpoenas. That has been proved. President Trump thus interposed the powers of the presidency against the lawful subpoenas of the House of Representatives and assumed to himself functions and judgments necessary to exercise the sole power of impeachment vested in the Constitution in the House of Representatives. That has been proved. President Trump abused the powers of his high office through the following means. Number one, directing the White House to defy a lawful subpoena by withholding the production of documents sought therein by the committees. That has been proved. Directing other executive branch agencies and offices to defy lawful subpoenas and withhold the production of documents and records from the committees, in response to which the Department of State, the Office of Management Budget, Department of Energy, and Department of Defense refused to produce a single record or document. That has been proved. Directing current and former executive branch officials not to cooperate with the committees, in response to which 9 administration officials defied subpoenas for testimony, namely John Michael McMulvaney, Robert B. Blair, John A. Eisenberg, Michael Ellis, Preston Wells Griffith, Russell T. Vought, Michael Duffy, Brian McCormick, and T. Ulrich Brechbuhl. That has been proved. These actions were consistent with President Trump's previous efforts to undermine United States government investigations into foreign interference in U.S. elections. That has been proved. Through these actions, President Trump sought to arrogate to himself the right to determine the propriety, scope, and nature of an impeachment inquiry into his own conduct, as well as the unilateral prerogative to deny any and all information to the House of Representatives in the exercise of its sole power of impeachment. That has been proved. In the history of the Republic, no president has ever ordered the complete defiance of an impeachment inquiry, or sought to obstruct and impede so comprehensively the ability of the House of Representatives to investigate high crimes and misdemeanors. That has been proved. The abuse of office served to cover up the President's own repeated misconduct and to seize and control the power of impeachment and thus to nullify a vital safeguard vested solely in the House of Representatives. That has been proved. In all of this, President Trump has acted in a manner contrary to his trust as President and subversive of constitutional government, to the great prejudice of the cause of law and justice, and to the manifest injury of the people of the United States. That has been proved. Whereas, or wherefore, President Trump, by such conduct, has demonstrated that he will remain a threat to the Constitution if allowed to remain in office, and has acted in a manner grossly incompatible with self-government and the rule of law. That has been proved. President Trump thus warrants impeachment and trial, removal from office, and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. That will be for you to determine. Let me say something about this second article. The facts of the President's defiance of Congress are very simple, because they were so uniform, because they were so categorical, because they are so uncontested. But do not mistake for a moment the fact that it was simple and quick to present that course of conduct compared with a sophisticated campaign to coerce Ukraine into thinking that that second article is any less significant than the first. Do not believe that for a moment. If there is no Article 2, let me tell you something. There will never be an Article 1. If there's no Article 2, there will never, of any kind or shape or form, be an Article 1. And why is that? Because if you and we lack the power to investigate a president, there will never be an Article 1. Whether that Article 1 is abuse of power, or that Article 1 is treason, or that Article 1 is bribery, there will never be an Article 1 if the Congress can't investigate an impeachable offense. If the Congress cannot, because the President prevents it, investigate the President's own wrongdoing, there will never be an Article 1. Because there will be no more impeachment power. It will be gone. It will be gone. As I said before, our relationship with Ukraine will survive. God willing, our relationship with Ukraine will survive, and Ukraine will prosper, and we will get beyond this ugly chapter of our history. But if we are to decide here that a President of the United States can simply say, under Article 2, I can do whatever I want, and I don't have to treat a co-equal branch of government like it exists. I don't have to give it any more than the back of my hand. That will be an unending injury to this country. Ukraine will survive, and so will we, but that will be an unending injury to this country, because the balance of power that our founders set out will never be the same. Will never be the same. If a president can simply say, I'm going to fight all subpoenas. And I'll tell you something else. Truism in the courts is just as true here in the Senate, where they say justice delayed is justice denied. You give this president or any other the unilateral power to delay as long as he or she likes to litigate matters for years and years in the courts, and do not fool yourself into thinking it is anything less. In April, it'll be a year since we subpoenaed Don McGahn, and there is no sign of an end to that case. And I'll tell you, when it gets to the Supreme Court, you might think that's the end, and that's just the end of the first chapter. Because Don McGahn is in court saying, I'm absolutely immune from testimony. Now, that's been rejected by every court that's looked at it. But we'll see what the Court of Appeals says, and then we'll see if it goes to an en banc Court of Appeals, and then we'll see what the Supreme Court says. And when we prevail in the Supreme Court, you know what happens? That's not the end of the matter. It comes back to the trial court, and then, well, they can't claim absolute immunity anymore. They can't claim that we don't even have to bother showing up. So now we're going to turn to Plan B, executive privilege. We're going to say we can't and won't answer any of the questions that are really pertinent to your impeachment inquiry, and let's start out in district court, and then go to the Court of Appeals, and then go en banc, and then go to the Supreme Court. You can game the system for years. Justice delayed is justice denied, and so is true about presidential accountability. So, when you suggest, or I suggest, or anyone suggests, or the White House suggests, why doesn't the Congress, why didn't the House just exhaust their remedies? As if in the Constitution where it says the House shall have the sole power of impeachment, there's an asterisk that says, after exhausting all court remedies, and first seeking court in the district court, and then seeking relief in the Court of Appeals, and after that going to the Supreme Court. Let's not kid ourselves about what that really means. What that really means is you allow the president to control the timing of his own impeachment, or if it will ever be permitted to come before this body. That is not an impeachment power, that is the absence of an impeachment power. Article 2 is every bit as important as Article 1. Without Article 2, there is no Article 1 ever again, no matter how egregious this president's conduct or any other. It is fundamental to the separation of powers. If you can't have the ability to enforce an impeachment power, you might as well not put it in the Constitution. Now, shortly, the president's lawyers will have a chance to make their presentation. And as we will not have the ability to respond to what they say, I want to give you a little preview of what I think they're going to have in store for you, so that when you do hear it, you can put it into some perspective. I expect that they will attack the process. I don't think that's any mystery. But I want to tell you both what I expect they will share with you and what it really means. When you cut through all the chaff, what does it really mean that they're saying? So here's what I expect that they will tell you. The process was so unfair. It was the most unfair in the history of the world. Because in the House, they took depositions. How dare they take depositions? How dare they listen to Trey Gowdy? How dare they follow the Republican procedures that preceded their investigation? How dare they? And they were so secret in the bunker in the basement, as if whether it's on the ground floor or the basement or the first floor makes any difference. Those super secret depositions in which only 100 members of Congress, equivalent to the entire Senate, could participate. That's how secret they were. That's how exclusive they were. Every Democrat, every Republican on 3 committees could participate. Of course, that wasn't enough, so you had even more storm the skiff, right? So you have 100 people can participate, but you heard earlier, but the Republicans weren't allowed to participate. Okay, that's just false. You know how we did it in those super secret depositions? And you can look this up yourself because we released the transcripts. We got an hour, they got an hour. We got 45 minutes, they got 45 minutes. And we did that back and forth until everyone was done asking their questions. Now you'll hear, oh, Chairman Schiff was so unfair, he wouldn't allow us to ask our questions. Well, there were certain questions I didn't allow. Questions like, who's the whistleblower? Because we want to punish that whistleblower. Because yes, some of us in this House and in this House believe we ought to protect whistleblowers. So yes, I did not allow the outing of the whistleblower. So when they say the chairman wouldn't allow certain questions, that's what they mean. That means that we protect people who have the courage to come forward and blow the whistle. That we don't think, though the president might, that they're traitors and spies. To believe that someone who blows the whistle on misconduct of the serious nature that you now know took place is a traitor or spy, there is only one way you can come to that conclusion. And that is if you believe you are the state, and that anything that contradicts you is treason. That is the only way that you can conceive of someone who exposes wrongdoing is a traitor or a spy. But that is exactly how this president views those who expose his wrongdoing, because he is the state. Like any good monarch, he is the state. And you'll hear the president wasn't allowed to participate in the Judiciary Committee. Well, that's false too, as you've heard. The president had the same rights in our proceedings as President Nixon and President Clinton. But nonetheless, you'll hear it was so unfair. And one other thing that was really unfair is all the subpoenas were invalid because the House didn't pass a resolution announcing its impeachment inquiry. Never mind that we actually did. The problem was, they said, well, we hadn't, and then we did, and then the problem was, well, you did. Now, of course, as you know, the Constitution says the House will have the sole power of impeachment. If we want to do it by House resolution, we can do it by House resolution. If we want to do it by committee, we can do it by committee. It is not the President's place to tell us how to conduct an impeachment proceeding any more than it is the President's place to tell you how you should try it. So when you see that 8-page diatribe from the White House counsel saying, we should have been able to have a resolution in the House, or we should have been able to have this, what you should hear, what they really mean is Donald Trump had the right to control his own impeachment proceeding. And it's an outrage that Donald Trump didn't get to write the rules of his own impeachment proceeding in the House. You give a president that right, there is no impeachment power. But when you hear them say that, when you hear them complain about depositions that were the same as the Republicans, or the right to participate that was the same in Clinton and Nixon, and by the way, they weren't allowed to call witnesses, they said. Well, 3 of the 12 witnesses that we heard in our open hearings were the minority witness requests. So you'll hear those arguments, the most unfair in history. The fact is, we had the same process. In those other impeachments, the majority did not surrender its subpoena power to the minority. You know what it did? It said, you can subpoena witnesses, and if the majority doesn't agree, you can force a vote. That is the same process we had here. The majority does not surrender its subpoena power. Didn't in the prior impeachments, didn't in this one. When they say the process was unfair, what they really mean is, don't look at what the president did. For God's sake, don't look at what the president did. Now, you'll also hear, I think the second thing you'll hear from the president's team is attack the managers. Those managers are just awful. They're terrible people, especially that Schiff guy. He's the worst. He's the worst. And Exhibit A, he mocked the president. He mocked the president. He mocked the president as if he was shaking down the leader of another country, like he was an organized crime figure. He mocked the president. He said, it was like the president said, listen, Zelensky, because I'm only going to say this 7 times. Well, I discovered something very significant by mocking the president. And that is, for a man who loves to mock others, he does not like to be mocked. So it turns out he's got a pretty thin skin. Who would have thought it? Never mind that I said I wasn't using his words before I said it, and I wasn't using his words after I said it, and I said I was making a parody of his words. It's an outrage. He mocked the president. That Schiff. Terrible. Now, they will attack my other colleagues, too, for things said in the heat of debate here on the floor, as we were reaching the wee hours of the morning. And they'll attack some of my colleagues who aren't even in this chamber. Maybe they'll attack the squad. That's a perennial favorite with the president. If they attack the squad, you should ask, what does that have to do with the price of beans? But you can expect attacks on all kinds of members of the House that have nothing to do with the issues before you. And when you hear those attacks, you should ask yourself, away from what do they want to distract my attention? Because 9 times out of 10, it will be the president's misconduct. But look for it. Attacks on the managers, attacks on other House members, attacks on the Speaker, attacks on who knows what. It's all of the same ilk. Whatever you do, just don't consider the president's misconduct. You'll also hear attacks on the Constitution. Of course, it won't be framed as an attack on the Constitution, but that's really what it represents. And that is, abuse of power doesn't violate the Constitution. Presidents of the United States have every right to abuse their power. That's the argument. Okay, I know it's a hard argument to make, right? Presidents have a constitutional right to abuse their power. And how dare the House of Representatives charge a president with abusing his power? Now, I'm looking forward to that constitutional argument by Alan Dershowitz. Because I want to know why abusing power and trust is not impeachable now, but it was a few years ago. Because the last time I checked, I don't think there was a significant change to the Constitution between the time he said it was impeachable and the time he's saying now that apparently it is not impeachable. So I'm looking forward to that argument. But I'm also looking forward to Ken Starr's presentation. Because during the Clinton impeachment, he maintained that a president not only could but must be impeached for obstructing justice. That Bill Clinton needed to be impeached because he lied under oath about sex. And to do so obstructed justice. You can be impeached for obstructing justice, but you cannot be impeached for obstructing Congress. Now, I have to confess, I don't know exactly how that's supposed to work. Because the logical conclusion from that is Ken Starr saying that Bill Clinton's mistake was in showing up under subpoena. That Bill Clinton's mistake was in not saying, I'm going to fight all subpoenas. That Bill Clinton's mistake was in not taking the position that under Article 2 he could do whatever he wanted. Does that really make any sense? You can be impeached for obstructing your own branch of government, but you cannot be impeached for obstructing a co-equal branch of government. That would make no sense to the framers. I have to think over the centuries as they've watched us, they would be astonished that anyone would take that argument seriously or could so misapprehend how this balance of power is supposed to work. So I look forward to that argument. And maybe when they make that argument, they can explain to us why their position on abuse of power isn't even supported by their own Attorney General. So I hope they will answer why even their own Attorney General doesn't agree with them. Not to mention, by the way, the constitutional law expert called by the Republicans in the House, who also testified as to abuse of power, that it is impeachable, that you don't need a crime that's impeachable. Now, when you hear them make these arguments, cannot be impeached for abusing your power, this is what it really means. We cannot defend his conduct. And so, we want to make it go all the way without even having to think about that. You don't even need to think about what the president did, because the House charged it wrong. And so, don't even consider what the president did. That's what that argument means. We can't defend the indefensible, so we have to fall back on, even if he abused his office, even if he did all the things he's accused of, that's perfectly fine. There's nothing that can be done about it. Now, you'll also hear, as part of the defense, and you heard this from Jay Sekulow, was I think the last thing he said, the whistleblower! And then he stepped back to the table. The whistleblower! Now, I don't really know what that meant, but I suspect you'll hear more of that. The whistleblower. The whistleblower. It's his or her fault that we're here. The whistleblower. You know, I would encourage you to read the whistleblower complaint again. When you read that complaint again, you will see just how remarkably accurate it is. It's astonishingly accurate. You know, for all the times the president is out there saying that the complaint was all wrong, you read it. Now that you have heard the evidence, you read it, and you will see how remarkably right the whistleblower got it. Now, when that complaint was filed, it was obviously before we had our depositions and had our hearings, all of which obviated the need for the whistleblower. In the beginning, we wanted the whistleblower to come and testify, because all we knew about was the complaint. But then we were able to hear from first-hand witnesses about what happened. And then something else happened. The president and his allies began threatening the whistleblower. And the life of the whistleblower was at risk. And what was the point in exposing that whistleblower to the risk of his or her life when we had the evidence we needed? What was the point? Except retribution. Retribution, and the president wants it still. You know why the president is mad at the whistleblower? Because but for the whistleblower, he wouldn't have been caught. And that is an unforgivable sin. He is the state. And but for the whistleblower, the president wouldn't have been caught. For that, he's a spy, and he's guilty of treason. Now, what does he add to this? Nothing but retribution. A pound of flesh. You'll also hear the president's defense. They hate the president. They hate the president. You should not consider the president's misconduct because they hate the president. Now, what I've said, I leave you to your own judgments about the president. I only hate what he's done to this country. I grieve for what he's done to this country. But when they make the argument to you that this is only happening because they hate the president, it is just another of the myriad forms of please do not consider what the president did. Whether you like the president or you dislike the president is immaterial. It's all about the Constitution and his misconduct. If it meets the standard of impeachable conduct as we have proved, it doesn't matter whether you like him. It doesn't matter whether you dislike him. What matters is whether he is a danger to the country because he will do it again. And none of us can have confidence, based on his record, that he will not do it again, because he is telling us every day that he will. Now, you'll hear the further defense that Biden is corrupt, that Joe Biden is corrupt, that Hunter Biden is corrupt. This is their defense. This will be another defense, because what they hope to achieve in the Senate trial is what they couldn't achieve through their scheme. If they couldn't get Ukraine to smear the Bidens, they want to use this trial to do it instead. So let's call Hunter Biden. Let's smear the Bidens. Let's succeed in the trial with what we couldn't do with this scheme. That's the goal. Now, I don't know whether Rudy Giuliani, who said he was going to present his report to some of the senators, has presented his report. Maybe he has. Maybe you'll get to see what's in Rudy Giuliani's report. Maybe you'll get to see some documents smearing the Bidens produced by who knows. Maybe the same Russian corrupt former prosecutors. But make no mistake about what that's about. It's about completing the object of the scheme through other means, through the means of this trial. You may hear the argument that what the president is doing when he is obstructing Congress is protecting the office for future presidents. Because there is nothing more important to Donald Trump than protecting the office of the presidency for future presidents. And I suppose when he withheld military aid from Ukraine, he was trying to protect future presidents. And when he sought to coerce a foreign power to intervene in our election, he was doing it on behalf of future presidents, because future presidents might likewise wish to cheat in a further election. I don't think that argument goes very far. But I expect you'll hear it. I expect you'll hear it. You may hear an argument that the president was really concerned about corruption, and he was concerned about burden sharing. I won't spend much time on that because you've heard the evidence on that. There is no indication that this had anything to do with corruption, and every bit of evidence that it had nothing to do with fighting corruption or burden sharing. Indeed, nothing about the burden changed between the time he froze the aid and the time he released the aid. There was no new effort to get others to contribute more, and Europe contributes a great deal as it is. This is an after-the-fact rationalization. You probably saw the public reporting that there was an exhaustive effort after the fact to come up with a post hoc rationalization for this scheme. I would like to show you the product of that investigation, but I'll need your help, because it is among the documents they refuse to turn over. They will show you just what an after-the-fact invention this argument is. Now, I expect you'll hear the argument, Obama did it. Obama did it. Now, that may take several different forms, but the form of Obama did it that I'm referring to is Obama also withheld aid. Honestly, I think that argument is an insult to our intelligence, because the argument is Obama withheld aid from Egypt, and he made a condition with it. Obama withheld aid from Egypt after they had a revolution, and circumstances changed. And you know something? He didn't hide it from Congress. In fact, Congress supported it. And yes, there are times when we withhold aid for a good policy reason, not a corrupt effort to get help in your election. The American people know the difference between right and wrong. they can recognize the difference between aid that is withheld for a malicious purpose and aid that is held in the best interests of our national security. But you'll hear the Obama did it argument. You will hear the call was perfect. You'll hear the call was perfect. Now, I suspect the reason they will make the argument the call was perfect is because the President insists that they do. I don't think they really want to have to make that argument. You wouldn't either. But they have a client to represent, and so they will make the argument the call was perfect. And they will also make the argument, Ukraine thinks the call was perfect. Ukraine says there was no pressure. What that really means is Ukraine wants a future. Ukraine knows it's still beholden to us for aid. Ukraine still hasn't gotten in through the door of the White House. Ukraine knows that if they acknowledge that they were shaken down by the President of the United States, the President of the United States will make them pay. So when you hear them say, Ukraine felt no pressure, and their proof is because the Ukraine president doesn't want to call the President of the United States a bad name, you'll know why. Because they need America. They need America. The framers did not expect you to leave your common sense at the door. Now, you'll also hear the defense. The President said there was no quid pro quo. The President said there was no quid pro quo. I guess that's the end of the story. This is a well-known principle of criminal law that if the defendant says he didn't do it, he couldn't have done it. If the defendant learns that he's been caught and he says he didn't do it, he couldn't have done it. That doesn't hold up in any court in the land. It shouldn't hold up here. You also hear a variation of the argument, no harm, no foul. They got the money. They got the money. And they got the meeting even though they didn't. They got the meeting on the sideline of the UN. It's kind of a drive-by, but they got a meeting. No harm, no foul, right? A meeting on the sidelines is pretty much the same thing, right, as a head of state meeting in the Oval Office? Of course it's not. Why do you think at that meeting at the United Nations, the President of Ukraine was still saying, hey, when am I going to get to come to town? He certainly recognizes the difference, and we should too. What's more, there's every bit of harm and every bit of foul in withholding aid from an ally at war and releasing it only when you're caught. Russia knows now about the wedge in our relations with Ukraine. The moment Russia found out about this, and I have to imagine, given how good their intel services are, they did not have to wait for Politico to break the story any more than Ukraine did. In fact, there's so deep a penetration of Ukraine, I would have to expect the Russians would have found out at least as early as the Ukrainians did, if not earlier. The moment Ukraine learned and Russia learned, there was harm. Because Ukraine knew they couldn't trust us. Russia knew they could take advantage of us. There was immediate harm. And because someone is caught, because a scheme is thwarted, doesn't make that scheme any less criminal and corrupt. You get no pass when you get caught. Now, I expect one of the defenses you'll see is they will play you certain testimony from the House, where my colleagues on the other side of the aisle ask questions like, Did the president ever say he was bribing Ukraine? Did you ever see him actually bribe Ukraine? Did you hear him say that he was going to bribe Ukraine? Did you personally see this yourself? And if you didn't see it, if he didn't lay it out for you, then it couldn't have happened. 2 + 2 does not equal 4. You are not allowed to consider anything except for a televised confession by the president. And even then, don't consider it. So I imagine you'll hear some of that testimony where witnesses are asked, they work for the Defense Department, well, did the president ever tell you that he was conditioning the aid? Never mind that these are people who don't necessarily even talk to the president. But I expect you'll see some of that. As I mentioned before, you hear the defense. We claim privilege. You can't impeach the president over the exercise of privilege. Never mind the fact that they never claimed privilege. They never asserted privilege. And you know why? You know why they never actually invoked privilege in the House? Is because they know that if they did, they'd have to produce the documents and they'd have to show what they were redacting, and they didn't want to do even that. They knew the overwhelming majority of the documents and witness testimony, there was no even colorable claim of privilege. So they didn't want to even invoke it. All they would say is, maybe someday. But you will hear that you can't be impeached for a claim of privilege they never made. So what do all these defenses mean? What do they mean? What do they mean collectively when you add them all up? What they mean is, under Article 2, the president can do whatever he wants. That's really it. You know, that's really it, stripped of all the detail and all the histrionics. What they want us to believe is the president can do whatever he wants under Article 2, and there is nothing that you or the House can do about it. Robert Kennedy once said, "Moral courage is a rarer commodity than bravery in battle or great intelligence. Yet it is the one essential, vital quality for those who seek to change the world which yields most painfully to change." Moral courage is a rarer commodity than bravery in battle. I have to say, when I first read that, I wasn't sure I agreed. Moral courage is a rarer quality than courage in battle? It just doesn't seem right. I wasn't sure I really agreed, and for a Democrat not to agree with a Kennedy is kind of a heresy. I'm sure some of my GOP colleagues feel the same way about the Kennedys from Louisiana. After all, what could be more brave than courage in battle? What could be more rare than courage in battle? But then I got to visit, as I know all of you have, our service members around the world, and see just how blessed we are with an abundance of heroes by the millions who have joined the service of this country. Service members who every day demonstrate the most incredible bravery. I just have the greatest respect for them, for people like Jason Crow and John McCain and Daniel Inouye and so many others who've served in this body and the other, or who've never served in office, by the millions all around the country and all around the world. It's the most incredible respect. It's an amazing thing how common is their uncommon bravery. My father's 92. He's probably watching. He's part of the greatest generation. Left high school early to join the service. He tried to enlist in the Marine Corps, and he failed the physical. So at the end of World War II, failed the physical. Bad eyesight and flat feet, which was apparently enough to fail the physical. So 2 weeks later, he went to try to enlist in the Army, thinking that maybe it's a different physical standard, and even if it isn't, maybe I'll get a different examining physician. Turns out, same standard, same physician. And he recognized my father. And he said, "Weren't you here 2 weeks ago?" And my father said, "Yeah." And he said, "You really want to get him that bad?" My father said, "Yeah," and he was in the Army. Now, the war was over, and so he never left the United States. And when he left the service, he went to the University of Alabama. And about midway through, he wanted to get on with his life, and he left college and went out into the business world. Something he always regretted, leaving college early. But I think in many ways, he got a better education than I did. I think that I was lucky to get a good education. But I think those like Jason and others who served in the military and also went to school got the best education. Because I think there's some things you can only learn by being in the military. Certainly, you can't really learn, I think, about war without going to war. And maybe there are things you just can't learn about life without going to war. So those of you that have served have the most complete education I think there is. But even so, is moral courage really more rare than that on the battlefield? And then I saw what Robert Kennedy meant by moral courage. Few, he said, are willing to brave the disapproval of their fellows, the censure of their colleagues, and the wrath of their society. And then I understood by that measure just how rare moral courage is. How many of us are willing to brave the disapproval of our fellows, the censure of our colleagues, and the wrath of our society? Just as those who have served in uniform can't fully understand, those who have not served in uniform can't fully understand what military service means, so too there is a different kind of fraternity or sorority among those who have served in office. I always tell my constituents there are two kinds of jobs in Congress. And it's not Democrats and Republicans. It's those from a safe seat and those from an unsafe seat. And I'm sure the same is true of those from a safe state and an unsafe state. It's why I think there's a certain chemistry between members who represent those swing districts and states, because they can step into each other's shoes. And one of the things that we in this fellowship of office holders understand that most people don't is that real political courage doesn't come from disagreeing with our opponents, but from disagreeing with our friends and with our own party. Because it means having to stare down accusations of disloyalty and betrayal. He's a Democrat in name only, or she's a Republican in name only. What I said last night, if it resonated with anyone in this chamber, didn't require courage. My views, as heartfelt as they are, reflect the views of my constituents. But what happens when our heartfelt views of right and wrong are in conflict with the popular opinion of our constituents? What happens when our devotion to our oaths, to our values, to our love of country, depart from the momentary passion of a large number of people back home? those are the times that try our souls. CBS News reported last night that a Trump confidant said that GOP senators were warned, vote against your president, vote against the president, and your head will be on a pike. Now, I don't know if that's true. Vote against the president and your head will be on a pike. I have to say, when I read that, and again, I don't know if that's true, but when I read that, I was struck by the irony. By the irony. I hope it's not true. I hope it's not true. But I was struck by the irony of the idea when we're talking about a president who would make himself a monarch, that whoever that was would use the terminology of a penalty that was imposed by a monarch, a head on a pike. Just this week, America lost a hero, Thomas Railsback. He passed away on Monday, the day before this trial began. Some of you may have known or even served with Congressman Thomas Railsback. He was a Republican from Illinois, and the second-ranking member on the House Judiciary Committee when that committee was conducting its impeachment inquiry into President Nixon. In July of 1974, as the inquiry was coming to a close, Congressman Railsback began meeting with a bipartisan group of members of the House, 3 other Republicans and 3 Democrats. Here in the Senate, they might have called them the Gang of 7. They gathered and they talked and they labored over language and ultimately helped develop a bipartisan support for the articles that led a group of Republican senators, including Barry Goldwater and Howard Baker, to tell President Nixon that he must resign. Some say that the Nixon impeachment might not have moved forward were it not for those 4 courageous Republicans led by Congressman Railsback. And it pained the congressman because he credited Nixon with giving him his seat, with getting him elected. He did it because he said, because seeing all the evidence, it was something we had to do because the evidence was there. One of his aides, Ray LaHood, eulogized him, saying he felt an obligation to the Constitution to do what is right. Now soon, members of this body will face the most momentous of decisions. Not, as I said at the outset, between guilt and innocence, but a far more foundational issue. Should there be a fair trial? Shall the House be able to present its case with witnesses and documents through the use of subpoenas, as has been the case in every impeachment trial in history? Now, the President's lawyers have been making their case outside of this chamber, threatening to stall these proceedings with the assertion of false claims of privilege. Having persuaded this body to postpone consideration of the witnesses and documents, they now appear to be preparing the ground to say it will be too late to consider them next week. But consider this. Of the hundreds of documents that we have subpoenaed, there is no colorable claim and none has been asserted. To the degree that you could even make a claim, that claim has been waived. To the degree that even superficially a claim would attach, it does not conceal misconduct. And what's more, to the degree that there were a dispute over whether a privilege applied, we have a perfectly good judge sitting behind me, empowered by the rules of this body to resolve those disputes. And when the Chief Justice decides where a narrow application of privilege ought to apply, you will still have the power to overrule him. How often do you get the chance to overrule a Chief Justice of the Supreme Court? You have to admit it's every legislator's dream. So let us not be fooled by the argument that it will take too long, or persuaded that the trial must be over before the State of the Union. This is no parking ticket we are contesting, no shoplifting case we are prosecuting. It is a matter of high crimes and misdemeanors. How long is too long to have a fair trial, fair to the President and fair to the American people? The American people do not agree on much, but they will not forgive being deprived of the truth, and certainly not because it took a back seat to expediency. In his pamphlet of 1777, The American Crisis, Thomas Paine wrote, "Those who expect to reap the blessings of freedom must undergo the fatigue of supporting it." Is it too much fatigue to call witnesses and have a fair trial? Are the blessings of freedom so meager that we will not endure the fatigue of a real trial with witnesses and documents? President Lincoln, in his closing message to Congress in December 1862, said this: "Fellow citizens, we cannot escape history. We of this Congress and this administration will be remembered in spite of ourselves. No personal significance or insignificance can spare one or another of us. The fiery trial through which we pass will light us down in honor or dishonor to the latest generation." I think he was the most interesting president in history. He may be the most interesting person in our history. This man who started out dirt poor, like hundreds of thousands of other people at the time. He had nothing. No money, no education. He educated himself. But he had a brain in that head, a brilliance in that mind, and made him one of the most incredible, not just presidents, but people in history. I think he's the most interesting character in our history. Out of the hundreds and hundreds of thousands of other Americans at the time, why him? Why him? I think a lot about history, as I know you do. Sometimes I think about how unforgiving history can be of our conduct. We can do a lifetime's work, draft the most wonderful legislation, help our constituents, and yet we may be remembered for none of that. But for a single decision, we may be remembered, affecting the course of our country. I believe this may be one of those moments, a moment we never thought we would see, a moment when our democracy was gravely threatened, and not from without, but from within. Russia, too, has a constitution. It's not a bad constitution. It's just a meaningless one. In Russia, they have trial by telephone. They have the same ostensible rights we do to a trial. They hear evidence and witnesses, but before the verdict is rendered, the judge picks up the telephone and calls the right person to find out how it's supposed to turn out. Trial by telephone. Is that what we have here? Trial by telephone? Someone on the other end of the phone dictating what this trial should look like? The founders gave us more than words. They gave us inspiration. They may have receded into mythology, but they inspire us still. And more than us, they inspire the rest of the world. They inspire the rest of the world. From their prison cells in Turkey, journalists look to us. From their internment camps in China, they look to us. From their cells in Egypt, those who gathered in Tahrir Square for a better life look to us. From the Philippines, those that were the victims and their families of mass extrajudicial killing, they look to us. From Elgin Prison, they look to us. From all over the world, they look to us. And increasingly, they don't recognize what they see. It's a terrible tragedy for them. It is a worse tragedy for us, because there's nowhere else for them to turn. They're not going to turn to Russia. They're not going to turn to China. They're not going to turn to Europe with all of its problems. They look to us because we are still the indispensable nation. They look to us because we have a rule of law. They look to us because no one is above that law. And one of the things that separates us from those people in Elgin Prison is the right to a trial. It's a right to a trial. Americans get a fair trial. And so I ask you, I implore you, give America a fair trial. Give America a fair trial. She's worth it. Thank you.
The Majority Leader is recognized.
Mr. Chief Justice, I ask unanimous consent the trial adjourn until 10 a.m. Saturday, January 25th, and this order also constitute the adjournment of the Senate.
Without objection, so ordered. The Senate is adjourned.